Be seated. All right, good afternoon, Lord. Okay, we're back on the record on case CR 22-211623, State of Idaho versus Chad Guy Daybell. We're going through small group board diary. This afternoon, we have another group here, and we'll have the jurors brought in. We are going to speak to one juror outside of the presence courtroom, and then we will return back to board diary. At this time, I'll instruct it. Marshall, would you please have those jurors brought in with the exception of the one.
All right, please. Depends on your honor.
Thank you. Please be seated. All right, ladies and gentlemen of the jury, we're going to get started here momentarily with the group board dire. However, first the court's going to meet with counsel briefly to discuss one particular juror, so we'll do that, please, in the jury room. I'll just meet with the state and the defense of this. Thank you. Please be seated. Okay, we are back on the record now on KCR 22211623, State of Idaho versus Chad Guy Daybell. Doing board dire of a small group this afternoon. Is the state ready to proceed?
Yes, Your Honor, thank you.
Is the defense ready to proceed?
Yes, Your Honor.
All right, thank you. I'll note on the record, I just met with one juror as well as counsel for both the state and the defense in chambers, juror 1187, who upon further review of the questionnaire and motion of the state as well as the defense has been excused for bias expressed in the questionnaire, in addition for a hardship as well. So we've allowed that juror to be excused, and we will next move on to the other jurors here. I will also indicate, last I heard, we had a juror scheduled for this group. Empty seat on the back row, juror 1605. Apparently has failed to appear and we haven't had word from them. Is that the latest status on this juror? All right, thank you, Mr. Bailiff. So juror 1605 has not appeared. With that then, in order to make sure we're all lining up our seating charts with where you are and who's here, if you do me a favor, please, and just hold your red card up and leave it up here for a moment while we take our notes. Okay, thank you for doing that. Having confirmed where these jurors are seated and who's here, then let me first inquire from the state, is there any objection to the manner in which this jury panel has been recalled and seated?
No, Your Honor, thank you.
Any objection from the defense?
No, Your Honor.
All right, thank you, counsel. Ladies and gentlemen of the jury, thank you for returning this afternoon. You've been recalled as prospective jurors in the case now before us. I'll reintroduce my court staff again and myself. I'm Stephen W. Boyce. I'm the district judge for Fremont County, Idaho, and I'm in charge of this trial in this courtroom. Our court clerk assisting today is Shannon Holstein, who's seated to my right. She takes minutes of these proceedings and also administers oaths to you as jurors. The court I have assisting me in maintaining courtroom order and working with the jury are marshals here today, and they will help the jurors know where they're supposed to be as they move about for these proceedings. Also, our court reporter, Mary Fox, takes a stenographic record of everything said during the trial, including today, and Courtney Stallings is my staff attorney who assists me with legal and administrative issues that come out throughout the day. Each one of you is qualified to serve as a juror of this court, and each one of you filled out a questionnaire that's now been reviewed by the attorneys and the court. And the first thing we do in a trial is to select 18 jurors in this case, which would include 12 jurors for trial and 6 alternates from among you. At this time, then, I am going to have clerk please take a roll call of the jurors that are here present. So when your name's mentioned, please hold up your red card and state either present or here so we get a record of who is attending. Madam Clerk, if you please take the roll call at this time.
Juror 977. Here. Juror 1185.
Here.
Juror 1219.
Here.
Juror 1248.
Here.
Juror 1271.
Here.
Juror 1288.
Here.
Juror 1330. Here. Juror 1353.
Here.
Juror 1366. Here. Juror 1382. Here. Juror 1436. Here. Juror 1503. Here. Juror 1537.
Here.
Juror 1557. Here. And Juror 1632.
All right, thank you, Madam Clerk. At this time, as I mentioned, we do have one juror who failed to appear, and for that juror, the court will require they report either by 5 p.m. or provide some explanation for the failure to appear. If there is no good explanation or further appearance, they may be subject to a fine up to $500 or imprisonment up to 5 days in county jail. That's pursuant to Idaho Code 7610 and Idaho Code 2208. Next, I am going to introduce you and to assist in participating in the jury selection process to the parties and their lawyers, and I'll briefly summarize what this case is about. When I introduce an individual, please stand and briefly face the jury panel, then retake your seat. This case has been brought by the state of Idaho. I will sometimes refer to the state as the prosecution. State's represented in this trial by Lindsay Blake, Fremont County Prosecutor, Rob Wood, Madison County Prosecutor, Ingrid Beatty is a specially appointed prosecutor in the case, and Rocky Wixom, a deputy Fremont County Prosecutor. The defendant in this case, Chad Guy Daybell, is represented by his lawyer, John Pryor. Good afternoon. This case is a criminal matter, meaning the defendant is charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges in the amended indictment, and you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho alleges that Chad Guy Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember that is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instruction as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you are instructed that you are not to discuss the case among yourselves or with anyone else, including any use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, I'm going to request that the clerk administer an oath to the entire jury panel for voir dire examination. If each of you would please stand and raise your right hand, I'll have that oath administered now.
You solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God.
I do.
All right, thank you. Please be seated. Clerk has now impaneled this group of prospective jurors for questioning. Will the attorney stipulate that the jurors have been properly called and impaneled, beginning with the state?
Yes, Your Honor, thank you.
Yes, sir.
All right, thank you. The attorney's then so stipulated. In this part of the jury selection, you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Fort Dyer is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law, and in Old French it simply means to speak the truth. Fort Dyer examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs. It's only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand or your red card. And when called upon to speak, please identify yourself by your card number, and also these proceedings are being stenographically recorded. So give a verbal response such as yes or no, shaking your head or nodding doesn't pick up and make a record. And also on that point, please try to avoid speaking at the same time as anyone questioning you. When only one person's talking at a time, our court reporter is able to make a clear record. I'll also note that the proceedings here are not only open to the public, but being broadcast on a court's channel on YouTube for public access. You are not being videoed or filmed. However, your audible responses are being broadcast. Keep that in mind when answering these questions. And if any question you believe would be embarrassing or something uncomfortable for you to talk about publicly, we will arrange to discuss that in a more private setting. Also, if you have an answer to some question that you think may prejudice the other jurors, or some information they may not know about the case, for example, please don't discuss that in front of the other jurors, and we'll talk to you individually about that. This case has had a lot of pretrial media coverage, and so any facts you may know, we'll talk to you one by one, and please don't discuss those in front of the rest of the jury panel. At this time, I am going to read you a special instruction being provided in this case, and this is as follows. The defendant, Chad Guy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the special instruction. At this time, I would also instruct attorneys for both parties to avoid repeating questions the court's already asked. You do have the right, however, to direct follow-up questions to a juror regarding that juror's response to a previous question. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, which means that they can ask a juror to be excused for a specific reason. In addition, each side has a certain number of peremptory challenges, which means each side can ask that a juror be excused without giving any reason. If you are excused by either side, please do not feel offended or feel that your honesty and integrity has been questioned. It has not. In addition, you may be questioned about your jury service once you're excused. If you are questioned by anyone, including members of the media, you are permitted to talk to them, but I would encourage you to respect the feelings of your fellow jurors, to not discuss anything that you think may impede the court in selecting an impartial jury while we're in this process. And if you don't want to talk to them and they persist, you could report that to the court. At this time, the court is going to begin its portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own inquiries. When I'm asking questions to certain jurors, please pay attention to those, as you may be called upon later to answer the same questions. First question I'll ask relates not the 22-page questionnaire you filled, but a juror information form, which contains information such as your residency in Ada County, for example. Is there anyone here that thinks the information in your juror information form is inaccurate and would need to be corrected? Okay, no one answered to that. I'll next ask on the questionnaire then, and without necessarily getting into the details, because those will be discussed, but is there anything you think within your questionnaire that at this stage you just need to change or correct? All right, no one responded to that. The next matter I want to bring up relates to the time commitment for this trial. This is scheduled to be a long trial, and parties have estimated it will take approximately 8 to 10 weeks. Given that time frame, would such service create a hardship upon you or your family or your business or profession or occupation so as to prevent you from rendering service as a fair and impartial juror in this case? If you believe you do have a hardship given the length of the trial, please raise your red card. All right, we've got 2 jurors that have responded to that. On the front row, could you raise yours again, please? Thank you. All right, at this point then, I'm going to address those hardship requests individually. So we'll start with the first juror on the front row, number 1248.
Should I go?
I was just reviewing your questionnaire real quick to see what you indicated. You did check the yes box for whether you thought there was a hardship. You said working full-time and losing that much income would be a financial burden. Have you been able to discuss your possible service with your employer in this case?
I discussed that with HR yesterday. They would only be able to cover 2 weeks.
And that is what they just confirmed yesterday.
Yes,
All right. Is that your sole source of income?
it is.
And if you were to be out 8 weeks of pay, would that financially strain you?
It would.
All right. Any follow-up questions from the state on or Dyer for hardship for this juror?
No, Your Honor, we actually had a note to follow up with juror 1248. I think given that additional information today, the state would make a motion to move for cause for the hardship. And that's exactly what we were going to follow up with today.
All right. Any for Dyer from the defense?
Judge, we would also need to excuse.
Very well. Juror 1248, we appreciate you coming in and taking the time to fill out the questionnaire and returning. I understand with that being your sole source of income and the length of this trial, that would constitute a hardship for you, so you can be excused from service. The bailiff will take your questionnaire, and thanks again for coming in. Juror number 1632 has indicated they would have a hardship also. You did mention in your questionnaire a concern about a trip planned, I think early June. Could you give some more explanation about what the trip is, when it is, and if it could be changed?
Trip is planned for June 4th through June 12th. So vacation, family reunion. Was canceled. I also do, as far as family, take my kid to school. My wife is a teacher who is starting her workday before our kids' school day.
Follow-up board Dyer, please, from the state.
Your Honor, the state does not have any additional questions. We would simply submit to the court on this one.
I'll have a bit of a follow-up on the plans you have on that trip. Have you pre-purchased or already paid for anything such as flights?
They have not been purchased by me, they are being purchased by a family member. Potentially, it could be put off.
Okay. Mr. Pryor,
Tell me a little bit more about the family. It's a large extended family or?
I don't have a large family. I do have family in Alabama that,
That's what the family reunion, that's where it's.
yeah, my dad's side of the family.
So how many people are we talking?
It's my family, my parents, my brother and his wife, and then the people that live down there. Half dozen to a dozen.
And this was, what I recall, is that this was reset as a result of COVID. Is that right?
Correct. Yeah, back in, I don't remember the specific date, but back in 2020 or 2021, it was canceled because of COVID. Yes.
And are other relatives flying in from other parts of the country as well?
Just my brother and his wife started flying in from Maine.
Judge, I'm going to submit to the court.
Juror 1632, if you remained in and missed the trip, do you think that would become a distraction for you, knowing that you missed out on a trip that's been planned for several years here?
Possibly.
I understand. Given that it was already rescheduled and canceled once, it is a long trial. There's a likelihood we may well be in the trial on those dates. I am going to permit for your request the excusal for hardship. In addition, with your child care obligations as well, court will find you to be excused. So juror number 1632, thank you for coming in and completing a questionnaire.
Thank you.
You're welcome. Did anyone else have a concern on that issue they wanted to raise with the court? All right, well, thanks everyone for your commitment to being available for that time frame. The next issue we'll bring up then relates to whether or not you have any previous knowledge of this case. This case has had significant exposure and reporting in the media. If you have had any knowledge of that case, we'll discuss that with you individually. So all I'll ask at this time is if you do have some knowledge of this case, the facts of this case, or the issues involved within this case, would you please raise your red card? Or your hand, okay. If you'll give us a moment, we'll note these down. All right, thank you. We'll come back and question you individually about those matters. Next topic I'll raise is the subject matter of the case. I've read to you the charges. Would the subject matter of this case, including charges involving murder, conspiracy, and insurance fraud, make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? No one answered yes to that. I'll next ask a series of questions that will seem very obvious perhaps to you, but I'm required to ask them under Idaho law to ensure that you don't have any kind of improper connection to this case or any of the people involved in the case. So the first question along those lines is, are you related by blood or marriage to the defendant, Mr. Daybell, or do you know him from any kind of business or social relationship? No one said yes. Do any of you have a legal relationship relationships such as guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger, any of those kinds of relationships between any of you and any of the attorneys in the case. No one said yes to that. Are any of you a party in any civil action lawsuit against Mr. Daybell? No answer to that. Have any of you ever brought a criminal complaint against Mr. Daybell or been accused of a crime by any of the prosecutors that are here present today? No one responded to that. Do any of you have any kind of an attorney-client relationship with Mr. Pryor, either now or in the past, or his law firm? No one responded to that. Are any of you related by blood or marriage to any of the lawyers here, or do any of you know any of the lawyers from a professional, business, or social relationship? No response. Have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? There's no response there. Do any of you have any bias or prejudice either for or against the defendant, Mr. Daybell? There's no response there. Are any of you unwilling to follow the court's instructions as to the law you must apply in determining this case? No response. Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict? No response to that. Are there any of you that if you are selected as a juror in this case, would you be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? There's no response to that. I have one final question then. Do any of you have any other reason why you cannot give a verdict? All right, no one responded to that. That will conclude the report section of board hour examination. I'll next allow the state to proceed with its board hour group. Is that going to be Ms. Blake?
It is, Your Honor.
All right, Ms. Blake, you can proceed.
Thank you. And ladies and gentlemen, thank you for being back this afternoon. I know this has already been quite a process. You were all here last week to fill out a questionnaire. Now we have you back here today. We are going to go over questions with you today, just to get some information. I want to go over a little bit why we're doing that. As you sit here today as potential jurors, what we're trying to do is make sure we select a jury that feels that they can be fair and impartial and that they can hear all the evidence in this case, give it the weight they think it's due, and ultimately render a decision and a verdict in this matter. So we go through this, the defendant, Chad Daybell, is entitled to a fair trial, and the state of Idaho is also entitled to a fair trial. So that's why we go through these questions. We just want to ensure that that's what both parties receive. So as I ask you questions, I don't want anyone to feel like I'm picking on you, but I will call on some people, get some responses, and just kind of go from there. Also, as we do this, the judge has already told you, but if at any time I ask you something that you're not comfortable talking about in a group setting, that is totally fine. I may ask something that I have no idea, maybe something personal, something that you'd rather talk about not in front of everyone. Just let us know, and we'll do our best to make those accommodations. This is not meant to make anyone feel uncomfortable. That being said, I want to start with throwing out the term brutal honesty. I want you to think about that for a minute. And juror 1219, if you hear the term brutal honesty, what does that mean to you?
Seeing the facts for what they are and speaking your mind.
Thank you for that. And juror 1537, how about for you?
I'm just telling the truth, I guess.
Thank you. I appreciate both those responses. And would everyone agree that it may also mean you don't hold back, even if it might hurt someone's feelings? You're not going to do a white lie. You're not going to spare feelings. It's just going to be telling it how it is. Would everyone agree that that would be being truly honest or brutally honest with someone?
Yes.
Thank you. And the reason I go over that with all of you is as you sit here today, there's two reasons for this. One is today, as we're going through this process, I'm going to ask you all to be brutally honest. Don't hold back. If there's something you think we need to know, either party, tell us. That's what we're here for today. And the second part of it is, as we go through everything, if you're selected to be a juror, at some point, the judge will give you jury instructions. And he'll tell you at what point you can start deliberating with each other. And we need to make sure that when you're back deliberating, you can also be brutally honest or honest with each other as you go through that process. Hearing that today, does that cause any concerns for anyone? No.
No.
Thank you. And we all may have someone that we know is kind of our go-to. So for me, my oldest niece, I learned pretty quick when she was little. She hadn't learned any filter. She hadn't learned kind of the little white lies or to spare feelings. So if I truly wanted to know something, I could go to her. If I wanted to know how my hair looked or how an outfit looked, she just gave it to me straight. And do most of you have someone like that in your life, whether a kid or a trusted adult that you know you can go to for just the straight answer? Yeah. That's what we're asking you to do today. Just be that person for all of us here. Have all of you flown on a plane before?
Yes.
Like everyone has. So normally you get on the plane and at some point they tell you, hey, sit back, enjoy your flight. We're going to get to the destination at approximately such and such time. And they take off. If instead of hearing that announcement, you got on the plane and the pilot came over the PA and said, so I'm going to try to land the plane and I think we're going to get to the destination at this time and I'll do my best. Would any of you feel comfortable staying on that plane? No. And juror 1577, I think I saw a pretty emphatic shake of your head. Why wouldn't you feel comfortable staying on that plane?
There's too much doubt. There's doubt that I would make it.
You want that assurance. That's fair. And juror 1353, how about you?
I would hope he was joking.
And I think that's a fair answer as well. And the reason I bring that up is you're all going to be the pilot in this case, essentially. And we want to make sure that everyone can give us the assurance that, again, we've kind of talked about it, but that you'll be able to sit on the jury, hear the evidence, give it the weight you think it's due, and land the plane. Be able to give us that verdict after listening to everything and to be fair and impartial in doing it. Does anyone sitting here today have any concerns about your ability to do that? Thank you. The judge already talked to you a little bit about the charges in this case. And so as you all know, there's several counts of conspiracy to commit first-degree murder. And there are also several counts of first-degree murder. The victims in this case involve 2 children and a mother of 5. Because of the nature of the case, you will see some images that may be graphic. They may be disturbing to some people. It's the evidence in the case that you'll be presented with. Knowing that, does that cause anyone concerns about your ability to sit on this jury and weigh that evidence with all the other evidence and just give it the weight you think it's due? And juror 1330, I think that maybe was from you. Talk to me a little bit about that, if you're willing.
I feel like I can say that I would be fine. I think I can tell myself that I would be fine until I saw it. And as a mother, I might not be able to say.
So I don't want to put you too much on the spot, but I just want to talk to you a little bit more about that. So if you were given an instruction by the judge that you're to view all the evidence, give it the weight you think it's due, do you think viewing those type of images would have such an effect on you that you couldn't be fair and impartial and weigh the evidence, the other evidence?
No.
Do you think you would be able to view it, even though it might be
Be
upsetting?
impartial, absolutely. But could I look at it? Difficult.
And when you say difficult to look at it, if you knew you had to view all the evidence, do you think, even though it might be disturbing, which is normal, do you think you would be able to view it and then just give it the weight you think it's due in relation to all the other evidence you may see or hear?
Yes.
Thank you for that. And juror 977, I think you also are a mother. Does that cause you any concern about your ability to be able to view those images? Do you think that if shown them, even if they were upsetting to you, do you think you would be able to just weigh them and give them the evidence or the weight you think they're due in relation to all the other evidence that you may see or hear? Nothing about them would automatically make you form an opinion just based on those alone. Thank you for that. And juror 1288, I apologize. I think I missed a hand from you, so I'm sorry about that. Can you talk to me a little bit about your thoughts on that?
Yeah, I have two very young children. It would be very difficult for me to see that.
And kind of same line of questioning, while it might be difficult and it might be upsetting, do you think you would be able to view those images and give them the weight you think they're due in relation to any other and all other evidence presented in the case?
I think I would be able to, yes.
And I know there was a little bit of hesitation there, so I'm just going to follow up a little bit. If you looked at those images, do you think it would automatically cause you to form an opinion of guilt or innocence, or do you think you'd be able to just view it and wait until it's time to deliberate and form that opinion?
I think I would struggle to not make it.
And when we talk about an immediate opinion, do you think you would automatically attribute the images to the defendant and hold them against him? Or would you be willing to listen to all the evidence and make that determination?
I would be willing to listen, but I worry truthfully that I could be partial up perceived.
I may have just a moment, Your Honor.
Yes.
And juror 1288, we may follow up with you a little bit more in the individual, if you'll still bear with us and hang in there for this process. Thank you. So I also have a little kid, and in the mornings when he gets up, if I ask him, what do you want for breakfast? Nine times out of 10, it's cheesy eggs. And there is a very specific recipe that he likes me to follow. So it's the eggs and the milk and the cheese and salt and pepper. And if I modify it, he might get upset with me. He might refuse to eat it. Sometimes he might want some extra cheese and I'll do that for him. Do any of you have someone in your life like that, whether a kid or an adult you know that maybe has a specific recipe they like done just a certain way?
Yes.
And juror 1436, I think you had said yes. Can you tell me a little bit about that?
I have two kids, I'm pretty picky, and they want things a certain way, and if it's not made that way, then they don't want to eat it, so.
And oftentimes, are you willing to do it the way they want?
Majority, yeah.
Do you sometimes modify it?
Yes.
Fair enough. And juror 1185, how about you?
He's a pretty picky guy. Really like the seasoning or anything, so I try and do anything too
I'm
special.
having a little trouble hearing.
My son, I'll just repeat. So my son's pretty picky. If I try and add any like spices or anything to his food, which I'm always trying to do because I'm a chef, but he won't eat it.
And I noticed you were a chef, so I kind of wondered about that. So you deal with recipes a lot.
Yes.
And in your line of work, do you sometimes modify them?
Only if you have to.
So at times, do you just follow the recipe as is?
Yes.
And why do you do that?
Because it's what works.
And someone else has either determined that or you've maybe created the recipe yourself
Yes.
and you know that's what works. So in this case, because in our everyday lives, sometimes we might modify things a little bit. We may look at a recipe and say, I'm going to add or subtract this. I'm going to do it a little bit different. But again, we've talked about the jury instructions. The judge is going to give you very specific jury instructions. And in this situation, you won't be able to modify those. So it'll be whatever the judge instructs. That's it. That's the law. That's what you follow. And that will include some instructions regarding these particular crimes and what elements are required to be proven. So in that, kind of like ingredients in a recipe, the judge will outline what is necessary. Sometimes you might look at that and think, man, I really wish this element makes no sense to me. Why do they have to prove this? Or you may think, well, they should also have to prove this. This doesn't make any sense. But you don't get to modify it here. Does anyone have concerns about their ability to follow the instructions as given by the court?
No.
And one of, or some of the charges here deal with the crime of homicide. And you'll be given an instruction, and again, it's what's given by the judge that'll be what matters. But it will include something along the lines of that the individual was involved, that the defendant engaged in conduct which caused the death of a person. So that'll be one of the elements. What you won't see is there will not be an element that says the state has to prove what the cause was. So it'll say we have to prove someone did it, but we don't have to prove how they did it necessarily. Or we don't have to prove why the person actually died, what was the cause. Does anyone have concerns that if the state is able to prove that a murder happened, will anyone be thinking that the court should have added that element? Or will everyone be able to follow the court's instruction as given?
Yes.
Follow the instruction as given? Does that cause anyone concern sitting here today? Thank you. Anyone here an NFL fan? I see some nods, so we got quite a few. Juror 1271, you nodded your head.
Yep.
So Kansas City Chiefs won this year. You don't have to tell me how you feel about it. You can if you want.
Never, always.
Okay. So knowing that, and even with that, would you agree that every person on the Kansas City Chief team should get a Super Bowl ring?
Yes.
And that could include, and so even if the quarterback played a bigger role, do you think the punter should still get a ring? And the second string, even if they didn't play on the field? And why do you think that?
In my experience from growing up playing sports to my career now, is that sometimes the most underrepresented individual within that group actually is overwhelmingly a reason why there's a success to a plan being whatever that is, and it's not the one that's always sitting behind the camera. So it's very obvious to me that everyone should, right, for that reason. You don't understand what happens behind the scenes.
Right, thank you for that. And you're 1503. How about you? What do you think? Should everyone get the ring? And why do you think?
Well, I play soccer, I like team sports, so I think it's a collective effort to win. So, yeah. So yeah, I think everyone equally participates in that.
I appreciate those answers and thanks for the involvement. You heard the judge start to give an instruction regarding conspiracy, or he did give you an instruction regarding conspiracy. And he talked about it being an agreement by two or more persons to commit a crime. And the actual instruction he gave talked about that you're not to consider Lori Vallow Daybell or Alex Cox's guilt or anything that may be going on with their cases. And we all understand that. Everyone's in agreement that they'll follow that instruction.
Yes.
What you will hear about in this trial, though, are some actions that are alleged to have been taken by Lori Vallow Daybell and actions that have been taken by Alex Cox. And remember, a conspiracy is an agreement between two or more persons to commit a crime. An additional element is that then just one of those persons has to do an act in furtherance of the conspiracy. So just one person has to take an action that gets them closer to committing that crime. So if you were to hear evidence that there's you know, A, B, and C involved in a conspiracy, A, B, and C reach an agreement, and you think the state has proven that there's an agreement to meet a crime. And you think the state proves that all the individuals or the particular individuals involved wanted to commit that crime, wanted that crime to happen. And the state only shows that, say, person C did an act in furtherance. If given jury instructions describing conspiracy that way, would you be able to still hold person A or B accountable for the actions of person C, given that there had to be the agreement and just one person had to do something in furtherance?
No.
You wouldn't be able to? And that's juror 1353. So let's talk a little bit about that. What's your concern with that?
I think everybody should be responsible for their actions. You can talk about doing something, but doing it is completely different. So you're responsible for what you do, not for what you talk about.
And if you're told that conspiracy involves reaching an agreement, so we're talking about people meeting and agreeing to commit a crime, does that change anything for you that there's that agreement, that we're required to prove there's an agreement?
No, they have to do it. They have to commit the crime.
And if you were given a jury instruction that said, this is what conspiracy is, and you just have to find one person did an act in furtherance, would you find that hard or impossible to follow that jury instruction?
It would be impossible.
Your Honor, given that, the state would make a motion to excuse juror 1353 for cause.
Judge, can we approach?
Yes.
When they do a sidebar, they really do a sidebar all the way to the side. I've only seen them in front of the judge. I wonder why we don't hear anything. No, it's not just us. East Idaho doesn't have sound either. So evidently they forgot to unmute. I don't know why I'm crackling. I must unmute it. Unfortunately, for some reason, there's no sound right now. I'm not sure if they forgot to unmute or if it's muted for a reason.
Instruction, it says.
Here we go. It's back on.
Mr. Daybell or Chad doesn't have to take the stand and you can't hold it against him. Will you folks follow that and agree to follow that?
Yeah.
Thank you. The other thing is that he doesn't have to present any evidence. If he decides not to present a single shred of evidence, he doesn't have to do that. He doesn't have to say anything. He doesn't have to do anything. And if the state doesn't meet their burden and in some way falls short, Does everybody understand that the verdict needs to be not guilty?
Yes.
Okay. I want to go back a little bit to what Ms. Blake talked about in terms of an agreement. Does everybody understand what the word agreement means? You sure if you all understand what agreement means? And I'm going to, I left it over here, excuse me. I'm going to go to 1577, and I want you to ask or tell me what you think an agreement is.
Agreement to me is,
Well, let's make it easy. Does it have to be in writing?
No.
Does anybody believe an agreement has to be in writing? Can it be done verbally?
yes,
Okay, so there has to be some sort of verbal statement to each other and say, we have an agreement, right? And shake on it. Is that fair?
Yeah.
Does anybody disagree with that? Anybody? You are, okay.
Yeah.
Well, I'm gonna go down here first because I haven't heard from 1537, so go ahead.
I don't think you need to shake on it.
Okay. Okay, verbally, you have to sort of speak the magical words. Would you agree with that?
Yeah.
Okay, and then 1353. Yes. What do you think about that?
Well, it's like in marriage, you say I do, but you also have a signed marriage license. So there's a legal document there. It says that you're married. You
Okay.
can't just say, I love you and I marry you and be married. It doesn't work like that.
So if you beat around the bush and say, I kind of like you. I wouldn't mind spending some time with you and just make general representations about things. But, it's not particularly clear that you said, I do. Should somebody force them and say, well, you said I do, so you're married? Is that
No.
fair?
No.
So just beating around the bush and everything else, that's not really an agreement, is it?
No.
When it comes to marriage or anything else, right?
No, it's an opinion.
At 1185, you're shaking your head. Do you agree with that? Oh, I'm sorry. You're shaking your head. So I'm going to go to 1219. I want to hear your thoughts on what you think is necessary for an agreement.
Well, I have an interesting example.
Okay.
I agreed to sell my father a gun
Okay.
over the phone, and later on found out it was worth a lot more. And I backed out. We haven't spoken since.
Okay.
So he thought that was an agreement, and I honestly entered into it as an agreement.
Okay.
And then found out some more evidence, changed my mind and backed out.
Okay. So let me ask you this. What if he had just said to you, we're going to get back to the marriage thing too, because that's actually a really great example. But what if he had said to you, and what kind of gun are we talking?
Just a gallery gun,
Okay.
.22 Magnum.
Okay. Okay. What if he had just said to you, boy, I like that Magnum. And you said, I bet you do like it. In fact, it's black. It shoots straight all the time. And I've never had it fail on me. Do you guys have an agreement to sell that gun?
No.
Why?
It's really hard for me to answer.
All right, well, is it possible that you didn't come to eye and say, yeah, we've joined in this and we're gonna be doing this together?
In this
Is that
particular
feasible?
case, the value of the gun changed
Right,
from what we thought it was.
but leaving that aside, I'm just talking in general, talking about it. Just saying, that's a black gun. It's always shoot straight for me. And there was never any discussion specifically about buying it or selling. Just describing the gun, talking about the subject. Discussing the topic.
No.
Is that an
that's not
agreement? Okay, 1503. Is that? I am blessed, and she's, well, maybe I shouldn't say that. I am a lucky man. I have an absolutely gorgeous girlfriend, okay? Beautiful girlfriend. And this is gonna kick back at me. I know it's coming. And I think dearly of her, and I don't deserve her. And I don't know whether she would marry me or not, but we skirt around the issue a little bit. I really care for you. I like spending time with you. I see a future with you. An amazing cook. And we talk about a lot of things, and we love to cook together. And we talk about a future down the line, possibly, wanting to spend our lives together. I want to see the hands. If I made an offer of marriage to her, anybody think I made an offer of marriage to her, would you please raise your hand? And I want to identify you because she may get a hold of you and say, see, he told you all these things. But nobody believes that that's an offer of marriage or an agreement, right? And even though it was verbal, there still needs to be more than just talking about the subject, doesn't there? Yes. Okay, thank you. I think I want to move on a little bit. Have any of you made major decisions in your life that you really had to think about? Yes. Buying a house. Anybody buy a house? Okay. Buying an expensive car. Anybody? Things like that. Is that a recipe you follow to make a major decision in your life? No? Because you're the chef. And have you bought a house? Okay, have you bought an expensive car? Yeah. But I bet you bought some very expensive equipment to cook your food with. Well, I mean. Now, is there a recipe when you're going to buy that software or cookware and all of that stuff?
That's more of a method.
Right, okay. But it's not a recipe that you knock, check boxes off and go down the line. Yes, it's not.
1 cup of flour. 1 cup of
Right,
sugar.
right. So when we're talking about a case like this, and Judge Boyce instructed us a little bit about this. And he said, you're going to look at the facts and the evidence. Okay? Does anybody understand what facts and evidence are? Everybody understands that, right? Yes. Yeah. The pen is blue. The car is red. And you're going to hear facts. And you're going to hear evidence. But do you think, as part of making a decision, you should guess about some of the things? Is guessing involved when you're making a serious decision? And I just saw the shaking of the head, and I want to say it's 1436. Guessing is not part of it, is it?
No, not at all.
And the word speculate. Do you think you should speculate when you're making a big decision about something?
No.
Ever?
No.
And I want to move and talk to some other people because I don't want to feel like anybody's getting ignored here. So we'll go to 1382. What about this idea of speculation? Should we speculate about things when we're making a major decision? Should we guess? What about using a hunch? Saying, I'm going to use a hunch and kind of figure out what really is going on here. Is that fair? Okay. Can all of you commit that if you're chosen as jurors, that you're not going to speculate, make a hunch, or guess, and that all you're going to do is apply the facts and the evidence to the case? Can all of you raise your hand and promise, no, strike that, commit to me that you're going to do that? Can all of you commit to me that you're going to do that? Raise your hand, can I see them? Please, all of you, thank you. Okay. There are circumstances, I'll talk to you a little bit about this. Is there anyone in the jury pool who has been honest 100% of the time in their life and have never told a white lie, a fib, or anything like that? Please show me, because I'd like to see one for the first time in 30 years. Nobody. I'm sorry. People tell untruth. They tell lies sometimes, white lies, big lies, things like that, right? Yes. What do you think some of the big things are that people lie about? Let's go to 1353 again. How about relationships? People lie in relationships. 1366. People lie in relationships?
Yes.
Okay. $1288. People lie in relationships?
Yes.
Okay. Let's say that it's not me. Somebody goes out after dinner and has a few drinks and is with somebody that they shouldn't be. And they get home and their wife goes, "Where you were?" They were doing something else. Is that a situation where you would tell the truth and say, this is where I was? This is, nobody wants to find out that you're liking. Yes. Okay. There's an expression, and I tell some of the other jurors, and I don't know how they're taking this, but I listen to a wide variety of music because I'm old, probably older than everybody in the church. I'm sure I am. All of you. Some of you have had a lot of years on. And I'm a child, unfortunately, of the 70s, which means there was disco music. And if you know anything about it, exactly. And I didn't wear bell bottoms, I promise. Not a bell bottom guy. But I've listened to a lot of variety, a lot of music and different kinds of music. But I enjoy country music. It's just something that I enjoy. And there's a song, the title of the song is "Everything That Glitters Is Not Gold." And it talks about the interaction between a man and a woman. And I'd like to see if any of you can guess what you think that expression means. Anybody have any ideas about that? Anybody? Nobody wants to jump up. Go ahead. It's number 1271. 1271. You're right. I'm sorry.
I think probably in reference to that song, it's just because something makes you feel good or has that attraction to it. It's not always good for you. Be what I would say.
And I go back and then I think about this all the time. And where does the song take me? Many years ago, there was a very wealthy man who was about 92 years old. He was a millionaire. And he decided he just had to marry this 18-year-old girl. And it caused a lot of problems down the line, but he went into the marriage. And I think of that because I think, the 18-year-old girl glitters. Beautiful, wonderful. But how long did it take them to figure out that everything that glitters is not gold? And another situation is like this. Have any of you been in a job that you thought was going to be a great job? And then all of a sudden you got into the job and you realize, oh my gosh, I left my other job and now look what I've got. This blanks. Anybody been there? Anybody? No? None of you have ever had a job where you, go ahead. No, actually, we'll start with him and then we'll get to you. Go ahead, juror number 1288.
Yeah, just getting to a job where it was certain tasks or income was promised that sounded a lot better than it looks when you're doing the task.
And everything that glitters is not gold. And the difficulty is if you invest or you spend the time and go down that road and then suddenly realize, oh my, this isn't what I thought it was. And maybe you didn't have all the facts. And then I've been there. Anybody else? Juror number 1271, excuse me.
Yeah, kind of about to say same, except for everything that was promised, but you figured out that the people, the personnel are on. It's not like a good spot to work, so again, I have that regret. Nothing was misconstrued. Still, you realize like it's what I wanted to be, what I thought it was gonna be.
Or it could be worse than that. You meet somebody and you realize, oh boy, it's too late now. Look what I got stuck with. What is going on here? And juror number 977, you're very quiet, but you made eye contact with me and it looked like you wanted to say something. Nothing? You don't want to say anything. Okay. Okay. I'm going to go into the last subject and then I'm done. Okay? It's about time, right? It's about time. Ms. Blake talked a little bit about this. And I just want some comments on this, and I appreciate a little bit. I'm going to see if some of the other folks will discuss it a little bit as well. You're going to see graphic pictures. You're going to see very, very graphic pictures. And these pictures are going to hurt your heart. I am telling you, they're going to hurt your heart. They hurt my heart. And I want to make sure that when you look at these pictures, that the immediate reaction is not to take it out on him. Everybody at least commit to not taking it out on Chad when you look at these graphic pictures. Yes. Would you please just put your cards up or your hands up so I can see that? Thank you. No, I didn't see it. We see that a lot of instances where media outlets, TV shows, podcasts, all of these people throw these graphic images up on the screen to make a statement. Has everybody experienced that? And the point of it is to get a reaction from you. The point of it is to cause you to become upset, and then you do something. But until you've heard all of the evidence and made a decision about the case, would it be fair to look at these heartbreaking images and hold them against Chad until you've heard everything that's said? Would that be fair? It would be fair to hold it against him? Would we agree that no, it would not be fair to hold it against him? Yes. Folks, I want to thank you. I want to appreciate the time. I appreciate you being very straightforward. This has been very easy for me with you folks. You're extremely easy to talk to, and I want to thank you for that. Judge, that's all I have at this point. Thank you very much, folks. I appreciate it.
All right. Thank you, Mr. Pryor. At this time, then, that concludes our, we are going to talk to each one of you individually, also the presence of the other jurors. So at this point, we will begin with our lowest number, which would be juror 977. If you could remain, we'll have the other jurors excused to the jury room and brought back in one by one. Please. Thank you. Please be seated. All right, juror 977, you're not in trouble. We're doing this with everyone. Yeah. We wanted to discuss different topics that are best discussed outside of the presence of other jurors. And in this case, let me just take a brief moment to review your questionnaire. You talked somewhat in your questionnaire about potentially having a hardship based on the age of your children, and you didn't, however, I think, raise your card when we went through that earlier. Could you just describe if you think you are able to serve for this time period, given your obligations?
I just wanted to be honest. I mean, it would be extremely difficult, but I mean, we could potentially make it work. It came to the needs of that, I guess. I was just being honest. We can find childcare, but we also own a business, so it would be extremely difficult, but I wouldn't say it would be possible. So I was just trying to be honest about that.
So you're basically self-employed.
Yeah. My husband and I own an insurance business.
Okay, how involved are you in the day-to-day affairs of the business?
Very involved.
If you were required to serve for this time frame, with both thinking about your children as well as the business, do you think that could become a distraction, or would you be able to set that aside and focus on evidence here? It would take up the majority of your time, or nearly all of it, and energy mentally. However, we do intend to stop, which would give you some time during the days when you're not sequestered. I'll also mention there may well be a time when you would be required to be sequestered, and so you simply wouldn't be available to be with your family for a week or 2 weeks potentially. So given all that, I'll just allow if the state and defense would like to question her in relation to a potential hardship, and then we'll move on to some other issues to discuss.
You don't ask the hardship. We don't have any questions.
Prior.
When you talk about daycare, in addition to removing one of the two salaries in your family house by you being gone, you're gonna have to pay for that daycare.
No.
You know, so there won't be a cost for you to pay for daycare?
There won't be a cause for lose income because we would lose an employee, which is their fault. My husband would have to do my work.
Well, would you also be taking care of the daycare as well?
No, we would be putting that burden on my in-laws on top of what they already do.
Okay, so you're gonna be placing a burden on them. But there's gonna be a loss of income.
And I'm sorry, but talking about being frustrated and not becoming a distraction, that would definitely become a distraction. That would become the case for more than a day or two.
Okay, and it would almost surely be more than a day or two.
I guess I might be kind of confused about that. As far as like being away, as far as not being able to go back to our home for more than a week or two.
All right, and counsel, I don't want indicating very young children involved here with this family.
Judge, I intend to make a motion.
Go ahead, Mr. Fryer.
Judge, I'm gonna move to exclude, they are very young children, and they need to be away from children of that age for more than a day or 2 days, I view as a hardship. So I would move to exclude this juror on the basis of hardship.
Response from the state.
Your Honor, it's important for your family and your children. But to me, from the judge's last comment, she doesn't really understand the expectation, potential expectations, sequestration. And so I'm not sure, based on what the defense's motion was, that there's grounds to excuse her for hardship just because her children have to be 1 or 3 years old.
All right, Mr. Wixom. The questionnaire did state you would have a hardship, and I guess I just want to ask you that then, knowing that that is a very likely possibility or real possibility that would occur in this case where you would be sequestered away from your family for some time. How do you think that would impact you and your ability to focus solely on determining this case?
It would impact me greatly.
In what way?
Thank you.
Cause you to be distracted from focusing on the evidence and the law here?
Yes, if I'm away from my family for more than, 8 to 3:30, I believe, longer on some days. Impacted me.
Okay, and I'm talking about that sequestration time, if it was two straight weeks.
Yes.
Trying to sustain a challenge based on a hardship for juror 977. And I do very much appreciate your willingness to try to make these arrangements and accommodations. This is an unusually long and complex trial, so not all are like this. And thank you so much for taking the time to accurately fill out your questionnaire return today and provide these candid responses to the court. All right, thank you. You can be excused. Council, at some point, I've got to address a couple of concerns with our jury commissioner briefly, but we would do that during a break. We're in this individual section. We've got a ways to go. Is this a logical time maybe for a mid-afternoon break?
The state believes it will be, Your Honor. Thank you.
Very well. We'll take a break right now. We'll advise the jurors also that we're on break, and then we'll come back on continuing this juror number 1185.
All right, please.
on already. We know by looking he may be combative again.
Being heavy on us, throwing a pregnant lady to the ground. There are 4 cases where men and women in blue stooped so low as to arrest these innocent mothers. Disclaimer. On July 14th, 2022, sheriffs from the Los Angeles County Sheriff's Department initiated a traffic stop on an unidentified woman who was accompanied by her infant for driving with broken headlights. However, the traffic cop suddenly became a disaster for this woman and her child.
Really attached to me, bro. Please.
But listen, at this point,
She has a car seat. Can you please listen to hear me out, please? Please,
Okay.
please.
go ahead, talk to me.
Listen,
Hey, I'm listening.
I can get a car seat for her.
I
can have someone to-
I'm listening to you.
Look at me.
I am.
I'm a mother. I take care of these baby by myself.
Okay.
And I have done a damn good job. 'Cause look how big she is. Look how healthy she is.
I'm not saying you're doing bad job taking care of her. I'm
But
saying
that's what you
what
are.
happened.
You don't have to do all this. You don't have to take all our
I'm
kids.
saying what led up to it is the problem.
What led up to it? Because why did she tell us that we could take our baby? We can have somebody. Don't please don't take my baby.
Don't make this any harder than what it already is.
Why is it that she told that we could find somebody to come pick us up and come get the kids and put them in car seats? He has a car seat.
Okay, I'm
He
on
can
your
go
ground.
home. All I need to do is go get mine. I swear to God.
That's that point. We didn't realize you guys have that many kids. You guys each have a kid in the backseat.
You seen him when he flashed the light.
Okay.
You seen her baby. You seen mine, and you.
His mother was afraid of leaving her baby with the officers because she knew what kind of monstrous behavior was lurking behind those faces, and that fear was confirmed by what the officers later did to that infant.
No, we're not going to do that.
I don't want to have to snatch her and have my partners grab your arm. That's the last thing I want to do.
We're trying not to do
Okay,
that.
if you don't want to do that, then why won't you just let it
Because
just?
we're gonna take the baby one way or another, okay? And I don't want to be rude about it. So
If you guys have kids, then why don't you guys understand?
That's why
I
we're
always,
doing it.
I literally
nothing
never been in
personal.
trouble. I've never had a warrant. I don't have anything. Why can't I just save my baby?
all right, you ready?
No. Let me hold on to it.
The officers then threatened her, saying that she either gives them the baby or they will forcefully take it from her. Well, they did far worse than that.
My baby has never been in danger. There's never been any type of
Your baby was in
anything.
danger tonight. Just by being in this car without being in a car seat, driving around the town. That was
We
what
weren't
the baby
driving
was
around
in
the
danger
town.
for.
I was just trying to get home.
The baby was endangered, traveling in a motor vehicle without being in a child seat.
Okay, and they all knew that. They both
Everyone
shined the
knew
light. She seen her baby. They seen mine, and they seen the other baby. Y'all knew we had
We're
3
done.
babies in
We're
the car.
done with this conversation. It hasn't been going anywhere. You aren't
Because
listening
you
to what I'm
guys
telling
aren't trying to
We
understand.
are.
You're gonna give up the baby nicely, or am I gonna have to grab and you're gonna grab your hand? I don't want to do that, but those are your two options.
Can you please just listen to me?
you. We have. Okay.
Please?
Okay. She's gonna grab the baby.
Can you guys wait? No, listen, please. You're making the baby.
Stop.
Please, let me hold on to it for 2 more minutes, please. Please, 2 more minutes. 2 more minutes. No, please. Please.
The officers finally snatched the baby from her, which was just the last thing she wanted. But just wait until you see how these evil officers
No, I care about my baby, but I'm not about to my job order. Listen, okay, everybody, bro, I care about my baby, and y'all don't. My baby is fucking Mexican, bro. I'm They come about to take my baby, bro. My baby 3 months. My baby 3 weeks. You heard it, bro. You heard it, baby, bro. Oh my God, you're taking my baby, bro. Bro. You heard it, bro. You're breaking the leg, bro. Hey, get this over, bro. You're punching me, bro.
The woman was punched 3 times by the officer, all while she was holding her baby. After the officers were done with their immoral acts, they once again took the baby into their custody and put the woman in cuffs, revealing that the deputy who punched the woman has been removed from the work area. The incident is also under investigation by the DA and the FBI. There are no reports on the woman or her child. Sheriff Robert Luna called the incident completely unacceptable. It's unfortunate to see a mother crying helplessly for her baby like that. But that wasn't the only time when the boys in blue treated those who needed help so inhumanely.
You do not have any permission to go into my house.
Before we get to that, Officer Matthew McNichol.
Oh my God. Wow.
Responded to a 911 call reporting a domestic disturbance between a couple at a gas station. The 23-year-old woman, Norelia Laurent, who was 3 weeks pregnant, was parked at the gas station with her boyfriend when Officer Matthew reached the scene and committed a horrific act.
If everything's good, why are we getting all kinds of phone calls?
Because we having a dispute. What?
Okay, you're having to do this in public in my city. That's why.
Your city?
Yeah, my city, in the city of Boca Raton.
Okay.
So we're getting calls, and we have a child out here, and it's for 15 minutes. In 15 minutes, we're getting calls on you two.
My turn.
All right. Well, it had one thing to do with you in front of the car pounding on the hood that I saw. So why is that happening?
Because I was trying to get in the car. What? I didn't call you. She didn't call you. So what? What you need with me?
I need your ID.
I'm not giving you my ID.
Well, you're not leaving.
Okay.
And that is when Officer Matthew, who claimed to protect his own city, got triggered and decided to exploit the situation, evidently for his own benefit.
Ma'am, I need your ID, please. No, you're not going to wait for your mom. You're operating a motor vehicle in my city on the sidewalk. You're going to give me a motor vehicle license. Driving is a privilege in the state of Florida, and you will give me, ma'am, you will give me your license, please. You're parked on the side. This is a driveway. Give me, ma'am, ma'am, stop talking over me.
Why are you yelling? What is you yelling for?
I need your license, ma'am.
She ain't got to give you her license. We ain't call you.
You will give me your license, or I will arrest you.
You put me on the ground and I'm pregnant, you're going to get charged.
Ma'am, I need to see your license right now. I need to see your license. I need to see your license. You are blocking a through there. Ma'am, I need to see license registration. Ma'am, I need to see your license registration right now. You're not parked in a driveway.
It's surprising that no traffic laws were broken or that any sort of crime had been committed, yet the officer insisted on asking for these IDs. And when the couple straightforwardly denied them, here's what he did.
Ma'am,
Thank you.
ma'am,
Thank you.
if you don't give me, ma'am, if you do not give me a license registration, ma'am, I'm going to lock you up.
I don't care.
All right. Taser! Sit down. I don't care. You don't have a right not to give me a license registration. You're under arrest. Step up. I don't care. You're under arrest.
When her boyfriend got out of the car to protect his pregnant partner, he was grabbed by another officer. At that moment, just imagine the trauma their kids would be facing, who could be heard crying in the car.
You are under arrest, ma'am. Stop the dramatic. You're under arrest. Here he comes. Sit down. Sit out of my car. Out of my car. Put your feet in. Down the ground. Stop.
What is wrong with him? I asked for a sergeant.
You don't get a sergeant.
I asked for a sergeant.
He's coming.
She told you not touch her. Quick.
You don't have that right. Under arrest.
Tase him.
Yeah. Well, hold on one second.
Tase him.
Out 47. One more unit up here.
I was already there talking.
Sit down on the ground right now.
I'm not talking to you. I'm talking to him.
You don't have the right to not talk to me.
You trying to leave him alone?
Sit yourself down.
The officer then threatened the man, demanding that he sit down and talk to him after what he'd done to his girlfriend. It's astonishing how he then claims that the man has no right not to talk to him, considering himself somehow above the law.
Sit down on the ground. Sit down on the ground. Sit down on the ground. Put your hands behind your back. For what? Put your hands. What are you putting me under arrest for? Sure. What are you putting me under arrest for? Oh, what you doing all that for? What you doing all that for? What are you doing all that for? You are under arrest for resisting arrest and battery on an officer. What officer? I battery. Did I touch you? Yeah, man. Yeah, you did. I never swung at you. Yeah, you did. I was trying to get him off of her. I never swung on him. Yeah, you did, and it's on camera. Okay. Never swung on you, officer. Don't even say I swung on you, officer. You putting your hands up. I never slapped your face. Come on, man. Are you serious? I slapped your face? I slapped her face? I didn't say you slapped. You're slapping at my face. I was just on my hands. I was trying to tell you to get him right or wrong. He's doing his job. She's pregnant. She's 6. I'm telling, bro. I was talking to you calmly. I know you. I was talking to you calmly. He was doing his job, and then did you see how he came up? One more card, please. Did you see how he came up?
Instead of apologizing, Officer Matthews' colleague defended the scene, claiming that he was just doing his job as grabbing and throwing.
Stop it! Whatever happened. Her. No, I didn't. Stop it. That doesn't give you right to break the law. Right? It's on camera, right? It is on camera. It's on camera, right?
Following this incident, instead of charges being pressed against these clowns, Laurent was charged with resisting an officer without violence. The police chief acknowledged concerns and initiated an internal investigation and expressed professional service. Laurent hopes for drop charges and plans to pursue a civil case for justice. It's undoubtedly sad to see a pregnant lady being beaten by an officer who said he was there to protect. But now, let's head on to the case that'll leave you in total shock. On June 6, 2019, Officer Casey Barnum from the Greeley Police Department was alerted about a possible case of child neglect at a home when the mother, Rosie Perez, didn't allow her 16-year-old son inside the house for uncertain reasons. But let's see if Officer Casey handled the situation well or change.
Hello. Hi. So we're getting a call from your son saying you guys are kicking him out.
I actually just got home. He has a warrant out for his arrest.
Right. Possibly not doing court or something.
Yep, that's right. Yep, that is right.
He's calling us saying you're kicking him out of the house.
I just got home from court, like literally just walked into the house. It's been my sister, and he actually hasn't been allowed in my house because he did this the last time, and I had to do a well check because I was at work. So I did tell her not to open the door if he came back.
Rosie can be seen talking to the officer with pretty good manners and also had reasonable explanations for not allowing her son inside the home, as he has an active warrant against him. But the situation completely spiraled out of control.
Here, I'm gonna come outside.
He's not coming to go until after that.
Okay, it's not a warrant for that. It was a warrant today because he failed to show up for court. So let me explain to you, officer, what's been going on, okay? So first off, he's kicked my door down before. The whole entire thing. The other day I was at work, and I can't leave work to come and see what's going on. I have small baby children here, and he did this to my door while I was gone. While I was gone, not while I was here. So I did a well check. No, please hear me out first, because I know exactly where you're going with this. Okay? So I asked him on his birthday, which was Tuesday, to get his butt home.
Okay.
He failed to come home. I don't know if he told you that or not, but he failed to come home. Okay, so he went to my sister-in-law's house and has been there since. And I told him, if you're not here by Friday morning in order to go to court, Trey, I'm going to court on my own.
Rosie really sounds like a good, concerned mother who's just trying to teach her son a lesson so that he doesn't commit crimes for which he could then go to court. On the other hand, Officer Casey is patient and listens to her, but not for very long.
And am I kicking him out now? Yeah, he has a warrant out for his arrest. He's not welcome in my home until he gets that taken care of.
Okay.
Okay.
You can't do that.
Yes, I can. He's a fugitive. Yes, I can.
You can call. Listen.
Yes,
listen. I listen to you.
Okay, what?
You can call us if he comes, but you cannot say you can't come in. And if you lock him out, he can kick your door to get in because he lives here.
Okay, I'm gonna tell you something. He may not kick my door.
Okay.
Okay.
If you lock him out, he can.
Okay, I didn't lock him out. My sister did. If he is being a havoc while my sister is here babysitting my children, he is not welcome here.
She needs to call us. You can't.
Oh, we did call you. We did call. We did a well check. They came. The officer came and checked that. Okay. The officer came and did that. He hasn't been home since until today. Okay. Today he was locked out again, and the reason that he was locked out was because I wasn't home. When I'm home, then he can come.
That's not how this works.
That's so sad. Bye.
No, that's not how. Man, listen. That is
You
not how.
need to leave out of my house.
Stop.
I am. You do not have any permission to go into my house.
All right, we're back on the record after our mid-afternoon break. KCR 2221-1623, State of Idaho versus Chat Guy Daybell, conducting individual voir dire of these jurors, and our next juror to be brought in will be juror number 1185. All right, juror number 1185 is returned, and upon review of this questionnaire, I don't know that there's any further follow-up or dire needed on case knowledge, bias, or hardship. Is the state intended question on any of those areas?
I actually just had one one area of questioning just on one of the standard of proof questions, if that's all right, Your Honor.
Okay, why don't you start there with your inquiry? The court doesn't have any of my own voir dire at this point.
Thank you so much, Your Honor. Good afternoon. On page 8 of your questionnaire, if you could turn to it really quick, just so you can refer to it. It's question 2, subsection C. You had checked yes, that you feel that the burden of proof should be higher than proof beyond a reasonable doubt. And you had checked yes. If the judge provides you an instruction, well, actually, before I go there, could you kind of explain your thoughts on that?
Yes, so at first I'd like to say I filled this out with, after working all night and I may have had 0 sleep.
Yes.
So let's see what I wrote here.
Yeah, take a moment if you need to, sir. That's totally fine. And there's no right or wrong answers. We're just kind of trying to gauge your thoughts on this stuff.
Yeah, I think that, with this kind of thing, the proof should be beyond, absolutely certain.
Absolutely certain.
Absolutely certain.
So if you were to receive an instruction that said proof beyond a reasonable doubt is not a possible doubt or an imaginary doubt, was that something that you'd struggle with if you want absolute certainty?
Perhaps, yes.
Okay. Sir, so did you have anything to add to that?
Oh, no.
Okay. So if I'm understanding correctly, you hold a conviction that proof should be beyond any possible doubt whatsoever.
Yes.
And if I'm understanding you correctly, you'd have a difficult time following the judge's instruction if the instruction was proof beyond a reasonable doubt is not a possible doubt or an imaginary doubt. Is that fair to say?
So
It's okay. It's totally okay. It's totally okay.
I'm not sure I'm just fully understanding.
Okay, so let me ask you this. Are you saying that, well, let me ask you a different question. even if you held a personal belief that there should be proof beyond any and all doubt, not even like even proof beyond even a possible doubt, proof beyond even an imaginary doubt, would you struggle to follow an instruction that was different than that?
No.
Okay. I have no additional questions, Your Honor.
No questions.
Okay. And I do want to just be clear on that point then, for this juror. I did, in the beginning of what I was going through today with you, read an instruction, and it is the instruction that you would be given in this case. I just want to read that instruction again about what reasonable doubt, how it's defined in this case. And the instruction reads as follows. A reasonable doubt is not a mere possible or imaginary doubt. It is doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. And that's the definition part of that. Would you be willing to follow an instruction that is the standard you're to apply to the evidence in this case?
Yes, so using real tangible things.
Just that instruction, and that again is the definition, and you would be able to follow that instruction?
Yes.
Okay, I don't have a further question on that topic. Anything further from either side on that? All right, at this time then, without additional board ire on that, let's next take a look at the section of your questionnaire that is your attitudes regarding the death penalty, and where you've indicated you were operating on little sleep when you filled this out. If you don't mind turning to page 12 of your questionnaire. And so when you filled that out, you were just asking your opinions and attitude. Now that you are a prospective juror in this case, I'm going to advise you that it may in fact be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And when you're considering that, you have to consider that it, as it should be done, any penalty you are considering should be considered as if it is absolute and would be carried out in the case. So with that context in mind, in your answers, you stated right in the middle of that page 12, the question, do you support or oppose the death penalty? You said you would support. Is that the way you feel here today?
Yes.
Okay. If you please look then at page 13. You had a set of choices, 7, to accurately describe the way you feel about the death penalty. There's a mark there, I think closest to C. Am I to interpret that as C being your choice?
Yes.
Okay. C is a statement that says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that the way you would feel about the death penalty still here today?
Yes.
All right. Are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay, just one final question from me then. Are any views you have on the death penalty going to prevent or substantially impair you and your ability to be a juror in this case and to follow the court's instructions relating to the death penalty?
Okay.
Okay, that concludes my board ire on that topic. Does the state have a board ire?
No, I don't. Thank you, sir.
Any board ire from the defense? Okay, juror number 1185, that concludes your individual board ire. I'll have you return to the jury room with the bailiff. Thank you. We'll next talk to juror 1219. Will either council have an inquiry for 1219 on hardship or bias?
The statement, Your Honor. No, Judge.
Okay, thank you.
Judge, can I have just a minute? For some reason, it's not letting me back.
Yes,
May I have a moment for that?
yes. Yes.
It's not there?
I mean, it's large.
Got it, Judge. Thank
Okay, thank you. And we'll have juror 1219 brought in. All right, juror 1219 has returned. We have some additional questioning for you outside the presence of the other jurors. I believe you've got a copy of the questionnaire you filled out. If you do, would you please turn to page 12 of that? And that is the section of the questionnaire discussing your attitudes regarding the death penalty. When you filled out your questionnaire last week, do you recall thinking through these questions on the death penalty and providing these answers?
Yes.
I'm going to advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And when you consider it, consider that it should be done as if it is absolute and will be carried out in the case. When you're thinking about these responses. Knowing that, and with the time that's passed since last week, is there any change or amendment you would have to those answers, or would they still be true and accurate today?
No changes.
Okay. On page 12, you had a choice of do you support or oppose the death penalty, and you said support. Is that still your position here today?
Yes.
If you would please turn to page 13. On that page, you had a set of choices that describe the way you feel and what's most accurate. You picked C. C reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty?
Yes.
And you would be willing to follow any instructions about it in this case?
Yes.
All right, the next question I'll have then is, are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay, and finally, I'll ask you, is there anything you think or we should know about your views on the death penalty that could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions about the death penalty? All right, that concludes the voir dire of the court on that topic. Does the state have any voir dire?
The state has no questions, Your Honor.
No questions, Judge.
All right, juror 1219, that concludes our individual voir dire. If you could please return to the jury room with the bailiff, we'll call it another juror and let you know what's happening once we return you.
Thank you.
1271 will be up next. I know there was some tech issue here. Are the parties able to access that questionnaire? All right. So I don't know if it was advised for 1271. Okay, thank you. All right, juror number 1271 has returned for additional individual voir dire questioning. I'd note that this juror does have some case information and raised their card when asked if they did know something about the case. So we'll discuss that, and you can certainly openly discuss any facts you know about that here with the other jurors not present. There wasn't any indication that there may be a hardship, so I don't have any of my own voir dire in terms of bias. I'll allow the state to ask me questions about that, followed by the defense, who will do that for the state.
I will, Your Honor.
Go ahead, Mr. Wicks.
Thank you. Sir, in reference to what the court had just said, you had made some early responses that you do have some case information. Can you just kind of give us a nutshell of what you understand about this case before you came here?
Yeah, and I didn't know if it was the right time to ask the question, but I assume most people have some. That was kind of my take with it, is that I've just heard news clips, stuff like that. There was, I've heard Lori Fallow, the other person that you guys maybe mentioned was possibly a conspiracy. I don't know that name. I've seen a lot of like just news clips that have popped up on it.
On that point, I understood you said you didn't know this other person. Did you see or learn enough that you even remember the names of the victims, the alleged victims?
It kind of rings a bell. I hear it. I couldn't listen right now. I know that it's 2 kids. I know that just like random little tidbits that maybe Hawaii was in part of it or something like that, but not like I don't know a ton of details about the case. It's just I obviously have, sometimes sit and see news clips and stuff like that.
Did you happen to watch any documentaries like Netflix or
No.
anything like that?
No, no, it was just like, it was just news clips that, you know, it was obviously a long time that the spam was unfolding. So it was just constantly here, like, someone's maybe saying something like, oh, did you hear about that? And that's about it. I just don't.
Do you feel, based on whatever you did gather from what you're referencing, do you feel like you could set aside anything that you have learned and freely listen to evidence as it comes in and then be impartial in rendering whatever decision you might make as a juror?
Absolutely. Like I said, I don't know enough to even be like, really put a stance on. So, yeah.
Okay. The last question on this, on your questionnaire on page 19, you had noted, I don't know enough of what happened to form any ideas, and I also believe in innocence until proven guilty. What did you mean by that?
Just the fact that even, you know, hearing it, I'm a firm believer in the fact that, you know, like, I'm just listening to random clips, like you really don't know the whole story until sit down and do it. It's just, that's all it's, the little bit that I have heard absolutely doesn't really matter until you sit down.
So is it fair enough to say that you're going to presume his innocence until the state proves him guilty?
Absolutely.
Thank you. All right, I don't have any more questions.
All right.
Questions.
Okay. The next issue we'll discuss then, juror number 1271, relates to your attitudes regarding the death penalty. If you do have a copy of your questionnaire there, this is on page 12 and 13 where we're looking. And I am going to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So thinking about that, you did provide answers here. Do you believe the answers you provided are still accurate in the way you feel here today?
Yes, yes.
Okay, absolutely. You were asked if you support or oppose the death penalty on page 12. You said you support it. Is that still the way you feel?
Yes.
Okay, on page 13, there was a series of choices, 7, that go into some more detail about what you think most accurately represents the way you feel. And you selected option C, which says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still representative of how you feel about the death penalty today?
It is.
Are you in favor of the death penalty in every case where a murder has been committed?
No, I'm not.
All right, and finally then, is there anything about your views or beliefs in reference to the death penalty that you think could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions?
No.
Okay, thank you for your responses. Does the state have any more dire?
We do not, Your Honor.
Nothing, Judge.
All right, that concludes the board dire. Juror number 1271. We'll have you return to the jury room and the bailiff will give you further instructions. Next up will be juror 1288. And we'll have them brought in. Does counsel intend any more dire in this one in relation to hardship or bias?
Yes, Your Honor. This is a juror that we've left off some questioning to pick up again during individual.
Okay. Oh, correct. Thank you. All right, juror number 1288, thank you for returning. We are reviewing your questionnaire here. There were some concerns raised in the group board diary that state's going to ask about. In addition, if there's any other questions that could relate to a hardship, you can inquire there as well. The state can conduct individual board diary this year than the defense. Ms. White, is that you?
Yes, Your Honor.
Go ahead.
Thank you. Juror 1288, thanks for sticking with us. I know we'd had a conversation about graphic images and I said, maybe we'll pick it up in individual. So that's where I wanted to start with you. I know I kind of had put you on the spot and you may or may not have thought too much about it before coming in today. But I believe where we left off, and correct me if I'm wrong, but I think you did have concerns about your ability to view any images of that nature that you may have a reaction to, and then just weigh them in relation to other evidence. You probably had a little more time to think about it. Do you still have that concern?
I think I'm concerned about it. I think I want to be impartial and weigh it accurately. I do think I would struggle in associating that with my own personal situation. So that's.
Like we did talk about, and I won't get into specifics, but we did talk about you have some children. Do you think, because you've said you want to be impartial though, and obviously as you look at evidence and give it the weight you think it's due, you may weigh that out how you feel appropriate. Do you feel like something about seeing those images would make you automatically impugn guilt to the defendant without having heard before you've heard all the evidence and weighed it out? Would you automatically draw that assumption or conclusion, do you think?
I don't know if I would automatically assign guilt, but I think I would. I'd be a little emotional in my wanting to seek justice.
And that's fair. Do you think if instructed by the judge that you were to wait to form any opinion until having heard all the evidence and in reaching your conclusion, do you think you would be able to, even though you may have an emotional reaction, which is normal, do you think you would still be able to follow the court's instruction and wait until the end to make that a final decision for yourself?
Yes. Yeah.
Thank you. I don't have any additional questions on this.
All right, thank you. Mr. Pryor?
I guess I just want to clarify.
Microphone, Mr. Pryor?
I'd like to clarify a little bit if you don't mind. You see some graphic pictures, and I talked about that a bit. You're going to have to block out having some sort of reaction and putting the blame on Chad. Is that what I'm hearing?
That I would have to block it out, is that right? Yes.
So in other words, you would be predisposed, or bad word, you would be upfront. If you saw these pictures, you would instantly say, I want to blame him for this. But you'd have to stop yourself and wait until you saw the rest of the evidence. Is that what you're saying?
I'm saying it would be difficult for me to not make an immediate emotional reaction of wanting to assign guilt to somebody.
And that's what, and again, I want to remind you, there's no wrong or right answer here. Because I really appreciate your honesty. I'm grateful that you're being honest. And so I'll restate what I said. You would have and I don't want to say extremely, but you would have a very difficult time not assigning guilt to somebody after looking at those pictures, and it would have an impact on you while you were deliberating. Is that fair?
I think so, yes.
And don't take this personally, sir. No, please don't. Judge, I'm going to move for cause on this. I'm worried about the potential risk
All right, response from the state.
Your Honor, the state would submit to the court on this one.
All right, well, this is why we conduct these sometimes individually. Juror 1288, a few of those responses by sharing a concern of the defense that this is evidence that's likely to be admitted in the trial that may affect you in a particular way to shift a burden away from the defendant to which he's entitled. And so I appreciate you really thinking through. I can tell you very carefully considered your responses to these questions and believe that the challenge is best sustained in this point in our interest of trying to obtain the most impartial jury we can. So thank you very much for filling out your questionnaire and returning today. I'm going to sustain the motion to strike, and juror 1288 will be stricken for bias in this case. You can go ahead and go and return your questionnaire to the bailiff, and we'll move on to our next juror. Thank you. Let's talk to 1330. All right, juror 1330 is returned for individual for dire. Thank you for coming back in. We're reviewing the questionnaire now. And we're going to be asking you about the knowledge you have about this case in addition to possibly other topics. Because the other jurors aren't here, we wish for you to discuss this in as much detail as necessary to tell us what you know. And with that in mind, looking through the questionnaire and that you've acknowledged you have some case knowledge, I'm going to have the state begin with their individual voir dire as to any possible bias, and then we'll move on to the defense. Spady?
Thank you, Your Honor.
Go ahead.
Good afternoon, ma'am. Hi. I just have a few quick questions for you about media exposure in this case.
Yeah.
So in your questionnaire, you indicated that you come across some news on TikTok, online, but that it just kind of come up. You hadn't sought it out. Is that accurate?
The only one I sought out was the Netflix special.
The Netflix special, okay. And you watched the Netflix special?
About a year ago.
About a year ago, okay.
So it's not completely clear.
Okay. Would you, and this might sound like an odd question, but would you kind of just tell us what you remember about the Netflix special?
I remember there were several suspicious deaths. I remember that seeing aerial footage of presumably the area of land that they were found. I remember seeing the last photo of them alive. That's about it.
And the area of land that they were found, do you know where that was?
Near Idaho Falls, I think, area.
Do you know who owned that property?
My understanding is that it was the defendant.
Okay. So having watched that Netflix special, at the time that you watched it, did it cause you to form any opinions?
Well, I mean, everything we see on TV is formulated and produced for the benefit of the pockets of the people who own the TV.
So
I understand that. Now, would it sway me? Not necessarily, because they don't really care whether they're telling barely truth, half truths, approximate truth today's kind of thing for the sake of money. I wouldn't say that I'm personally swayed by anything I see online when it's a for-profit situation.
of course, I certainly appreciate that perspective. I did notice on page 19, when they asked if you could put out, when the questionnaire asked if you would be able to put out of your mind what you had read and heard, you'd initially checked no, but then you crossed it out and wrote yes. Was that something you've been kind of wrestling with a little bit?
No, I only checked the wrong box.
Oh, okay, all right.
It was one of those where I think I read something and then I checked it and I went, oh, whoops, that's totally the wrong box. So it wasn't a rethink of the same question.
Okay. And I realize this might all sound kind of silly since I'm the prosecutor in this case, but we all have an interest in making sure that Mr. Daybell gets a fair trial.
Correct.
He's innocent until the state proves him guilty.
Yeah.
And so I think thank you, madam. The concern that I guess I'm kind of wrestling with a little bit is, you talked about how emotional it would be to look at some of these photographs.
Yes.
So do you think that it would be very difficult to look at those photographs and still put out of your mind what you saw in that Netflix special?
I'd like to say that I can do that, but I don't think anyone truly knows what they would do until the moment they've seen those pictures.
Okay.
I've never seen pictures that graphic. Most of the stuff I watch is censored to a certain degree.
Well, thank you.
So you can assume what you might do. And I would think that I would still be partial to do.
Okay.
I like to believe that I would be.
But as you sit here today, you're kind of struggling with that.
You can tell yourself and you can say, you know what, I'm going to remain partial regardless of what I see. I don't think anybody really knows when something happens to them for the very first time in their life, what the outcome will be.
Thank you so much. Just one moment. And I want to thank you very much for your honest answers. Your Honor, the state, with all due appreciation for this juror's honesty, the state would move to excuse her due to the exposure that she's had in this case.
All right, response from the defense.
And Judge, I've struggled with this because she's been extremely honest. I appreciate how.
I want to be honest.
And you have been very forthright, and I've struggled a little bit with this, but in the end, I think, Judge, I agree with the state. I'm worried that those pictures are going to influence you, and I'm not sure I have guarantees that it's not going to be a problem. And considering what's at stake, it bothers me a little bit, but it's nothing personal.
I'd like to say that I know how I would react, but I've never had that happen.
That's what
you can't know.
Judge, I go along with the motion to strike.
Very well. The court's considered the request to strike juror 1330 on biased grounds based on previous exposure to case information. On review of the questionnaire, in particular, having viewed the Netflix documentary, which will contain potential evidence that would return in this case, I share that concern of counsel, and so I'll sustain the motion to strike. Juror 1330, thank you so much for coming in and participating in the process. You discharged your service as a juror in this case with the sincere thanks to the court.
You're welcome.
Thank you.
Thank you.
We'll next talk to 1353. All right, juror number 1353 has returned for individual Ford Dyer. There were some issues brought up in terms of Ford Dyer in the group when council was discussing the conspiracy charges in this case, and I indicated we delve into that further individually. In addition, in this case, I don't know that this juror had expressed any knowledge of the facts, but there is that issue to go through as well. On a hardship, we didn't really have anything to discuss there. I'll allow the state to proceed with any additional Ford Dyer relating to those questions that came up, and then I'll allow the defense to do their Ford Dyer on that as well.
Thank you, Your Honor. Juror 1353, you remember we were talking about the conspiracy?
Yes.
And so we talked about the judge would give you the recipe or the instructions, and they'd have certain elements. And with conspiracy, the judge had already said conspiracy would be an agreement between two or more persons to commit a crime. Would you have any problem with that?
It would have to be shown, proven, that there was an actual agreement, not just words spoken.
So when you say actual agreement, what would an actual agreement look like to you, if you could describe it?
Transfer of money, an action that would suggest that there was an agreement made.
And if the judge were to give you an instruction that says what agreement is defined as, so again, kind of like a recipe, the judge is going to tell you what an agreement means. So it could be various things and it could be implied. Would you be able to follow that instruction in determining whether or not an agreement had been reached? Would you have concerns with that?
No.
If you're instructed on it?
No.
And then if you felt that the state had in fact met the burden of proving there was an agreement based on the court's instruction of what an agreement is and that that's an element. And then another part of the instruction was that even if just one of those people do an act in furtherance, so one person does something to carry out the crime or to attempt to carry out the crime, would you then be able to say if there was an agreement, you could hold anyone involved in that agreement accountable?
I would have to ask who's on trial. If the person was on trial, there was an agreement, then I would have to agree with somebody that I don't know about and they agree to it. I have no idea. So I say no.
So I guess maybe I can explain it a little better. So the judge had talked about a couple other names coming up. So Alex Cox mentioned by the court. And the court said you wouldn't concern yourself with their guilt or innocence or any proceedings that they may or may not have going on. So if you knew you weren't going to consider that and you're only considering the defendant and you felt the state did prove that there was an agreement, but maybe you didn't feel the state proved that the defendant was the one that committed an overt act, but you believe the state met their burden with one of the other alleged co-conspirators, would you be able to follow the jury instruction regarding conspiracy to say if there's an agreement and one of the parties to the agreement commits an overt act, you could find someone guilty?
You have to restate the question because I'm confused. If you're saying that the person that's on trial has agreed to a contract or an oath, then I think we should be concerned about that person. If there were more people that were involved with the conspiracy, their actions should be tried separately. And so I'm always willing to listen to what the court has to say and is in charge, but that's beyond my scope to know and to understand what somebody else's intentions are.
And if you were able to hear evidence regarding some of those other individuals' actions or alleged actions, and you were told you could consider those actions as part of this trial, do you feel you would then be able to consider what action someone else took in furtherance of the conspiracy?
Once again, I'm confused by the question. Because what I'm saying is, if we have somebody on trial for a crime,
they should be proved guilty or innocent on what they've done. So somebody else talking about doing something or not doing something, notice it can be proven that they actually did that act. And if it's not to be allowed in this courtroom by the court, then that will be thrown out. But if it is allowed, then it's allowed. And if it's allowed by the judge, then I would have to agree that I can listen to that. But if it's not allowed by the judge, then it shouldn't be presented. Does that make sense?
Yes, I think I understand what you're saying.
Okay.
So it sounds like you would be willing to follow the instructions of the court.
Yes,
And if the court allows certain evidence in, you would consider all the evidence that's presented to you in making a determination.
absolutely.
And so do you believe if you think the state meets a burden of showing there was an agreement, of proving that you could then, if the court told you you could consider actions of another individual that may have taken those in furtherance of the conspiracy in reaching a final verdict?
Yes.
I don't have anything additional.
All right, thank you, Ms. Blake. Mr. Pryor.
It really comes down to a simple thing. The judge gives you instructions, you're gonna follow them, aren't you?
Yes, sir.
Nothing else, Judge. Thank you.
All right, thank you. Without additional voir dire on those topics, then the court's going to move on to the part of your questionnaire that dealt with your attitudes regarding the death penalty. So juror number 1353, do you remember coming in last week and going through that part of your questionnaire?
Yes.
Okay, and for your reference, we're looking at page 12 is that whole section about attitudes regarding the death penalty. I'm going to advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. With that in mind, I'd like to look at your responses, a few of them. You had a choice of do you support or oppose the death penalty, and you said support. Do you recall answering that way?
Yes.
Is that still the way you feel right now?
Yes.
On the next page, you had 7 different choices to select from. Which one would describe most accurately the way you feel? You selected choice D, which says, I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that still the way you feel about the death penalty as well?
Yes.
Okay. Are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay. Is there anything about any of your thoughts or views or feelings about the death penalty that you think could prevent or substantially impair your ability to serve in this case and follow instructions on that?
No, sir.
All right. Thank you so much for your responses. Does the state have any more data on that issue?
No, Your Honor, thank you.
Nothing further, Judge. Thank you.
All right, juror 1353, that concludes your individual voir dire. We'll have you return with the bailiff.
Judge, I'm wondering, just to keep the record clear, the state had made a motion to excuse juror 1353 for cause. I think the state would withdraw that request.
Very well. Clarifying the record, Ms. Flake, and juror, you can return with the bailiff. And while we're waiting for our next juror, which will be 1366, something I hadn't mentioned previously with this group, but the jurors in this group did all return their affirmations, and they were all okay, with the exception of the one we discussed on the record previously. Those will be contained in the case. questioning to take up with you outside the presence of the other jurors. In this particular questionnaire, the court didn't see any concern necessarily of a potential hardship. However, there may be some questions on either side of bias, and so I'll allow board eye on that topic and then move on to our next topic if we're still questioning. So does the state have any questions for this juror in relation to bias?
Just briefly, Your Honor.
Go ahead, Mr. Wood.
Juror 1366, I just a reminder, there's no right or wrong answers here. Just tell us what you're thinking, how you're feeling. It sounds like you've seen some media connected to this case. Is that fair?
I've seen headlines.
Headlines. Okay. So have you read articles or?
If I did, it was so long ago, honestly, I don't remember. I just really don't met headlines from living locally.
And you did state in your questionnaire that anything you had heard, you'd be able to put out of your mind and render an impartial verdict, correct?
Correct.
And you agree that this defendant has an absolute right to a fair trial?
Yes.
And to start out with a clean slate?
Yes.
And so can you commit to this court, to the state, to the defendant, that you will set aside anything that you have heard and render an impartial verdict based solely on the evidence in this court?
Yes, I can.
Stay has no further questions, Your Honor.
No questions, Judge.
All right, juror number 1366 then, in addition, there are some questions I'll have about the part of your questionnaire you filled out called attitudes regarding the death penalty. Do you remember when you came in last week and went through this questionnaire, thinking through and answering those questions?
Yes.
All right, the questionnaire then, well, first let me advise you that it may be necessary for you to actually make a determination in this case in regard to the imposition of the death penalty or some other penalty. And so remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So with that in mind, when you filled out your questionnaire, you had a choice of whether or not you support or oppose the death penalty. You said you support the death penalty. Is that still the way you feel here today?
Yes.
All right, the next question I'll have relates to the choice you made when you had 7 different choices that describe what most accurately represents the way you feel. You circled a selection saying, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the law. I'm sorry, by the facts, law, and instructions in the case. Is that the way you still feel about it as you sit here today?
Yes.
All right, so you would follow any instruction the court gives on that topic if that occurs in the case?
Yes.
Are you in favor of the death penalty in every case where a murder's been committed?
No.
Okay, is there anything else to be concerned about in terms of your views on the death penalty and anything you think where your views could substantially impair or prevent you from serving as a juror in this case?
No.
All right, I don't have any additional questions on that with this juror. Does the state have any more dire on the death penalty questions?
No, Your Honor.
No questions, Judge.
Okay, juror number 1366, thank you for returning back. We'll have the bailiff take you back to the jury room while we talk to our other jurors, and then you'll receive further instructions. Next up, 1382. All right, next year we're going to talk to your 1382. This juror did indicate some knowledge of the case through prior media exposure to the case. And we want to talk to you about that. And again, you can discuss that in as much detail as you can so that you know where you stand on those issues without the other jurors here present. And I don't believe the issue of hardship was necessarily for the court this time, so the state wants to inquire and board dire and bias. Do that, and we will be doing that.
I will, Your Honor.
Go ahead, Mr. Wicks.
Thank you. And again, thank you for being here. And there's no right or wrong answers to the questions we're asking. We just want to get a feel for your perspectives are. I want to start just by drawing your attention to page 18 of the questionnaire. And overall, it does not appear like you have a lot of information about the case, but you did indicate some information. Besides Channel 7 News that you mentioned, do you recall seeing any other news reports or documentaries or anything?
I have not. I mean, it's not a recall or a not recall. I have not.
I simply haven't seen that.
I've watched some commercials for Channel 7. So, story coming up at 10. I've gotten some headlines. That's about it.
So then on page 18, you did note, I've seen some Channel 7 news reports years ago regarding the bodies being found and her being arrested. So I'm just going to ask, as you sit there today, from what you can recall or remember, do you remember which bodies and where they were found?
Now, I know that I remember seeing, like I said, the previews to the stories and showing an aerial view of a property. So, no.
So is it fair to say that you don't even remember the names of the alleged victims, if you ever even knew them? Do you recall them as you sit there?
No, but I might be able to. No, I mean, if I sat here long enough, I probably could pick up the names. I don't.
Okay. Well, would it be safe to say that whatever information you did glean from the news over the years, could you set aside anything that you've learned from the news if you're asked to be a juror and just listen to evidence as it comes in and then make your own decision about whether or not there's, well, guilt or not guilt, no guilt. Okay. And then would you commit, I noticed on page 19, you said everyone has a right to their day in court and I'll say to be considered innocent until proven guilty. Okay, so you'll commit to that you won't make a decision about the defendant's guilt unless and until the state meets their burden and actually proves that he's guilty. Is that fair?
Yes.
No, I don't have any more questions.
All right, thank you, Mr. Wixom from the defense.
Just very briefly, ma'am, you had a very strong opinion about media. So I don't think I have any concerns about you listening to anything the media says. Is that fair?
That's fair.
Okay. And quite frankly,
Use your microphone, Mr. Fryer.
it is on, Judge, and I'm sorry, I'll speak into it. And you were very specific. You said everybody has a right to their day in court, and you underline the proven, which means you're going to make them prove their case, the prosecutors, right?
Absolutely.
Okay, Judge, I have nothing else. Thank you, ma'am, for your time. Thank you.
All right, thank you. I guess, have one question I'll raise in terms of the hardship section. You talked about your position at work, can go on 24/7, and you said I would just work after the court hours. I guess one concern I'd like to talk through with you is if your thinking might continue with full or part-time employment. If you find this to be taking up all of your mental energy and you're not able to work the way you think you would, are you concerned that you might have some hardship if you really can't work while this trial's going?
I wouldn't have a problem with it. My position is, it could probably be done extremely easily, with remote. And I do have backup in other, I'm one of a group in HR, so I'm not restricted to the parts that I'm participating in at work.
Okay. If there were a time that you were sequestered a week, possibly 2 weeks, and you just simply couldn't work at all, would that create any kind of hardship?
Yes.
All right, thank you for just answering those follow-up questions for me. The other topic I want to discuss with you is on your attitudes regarding the death penalty. That's a section that we had you fill out in the questionnaire. Do you recall that?
Yes.
I'll advise you in this case that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you consider should be done as if it is absolute and will be carried out in this case. Understand that?
Yes.
All right. When you had a choice of do you support or oppose the death penalty, you didn't like the choice of yes or no and circled support, clicked the box, and also wrote depends next to it. And that's fine. This is designed to understand how you think about it. And so it looked like yes or no was not enough description for you. You also checked a choice saying, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. So could you explain, as you sit here, as best you can, your views on the death penalty?
That's my issue, or my choice of answers have more to do with the question. So at the end, when all of the evidence has been shown, then ask me yes or no. I wouldn't want it to be taken out of context.
Okay.
Whether I would agree, yes, death penalty is appropriate, or no, it's not. Because I think it's all situational on the facts of the case, not just an open-ended question.
All right. If you are given specific instructions in this case that say you are to consider the death penalty, would you follow those instructions?
Yes, absolutely.
And if you were given instructions that say you are not to consider the death penalty, would you follow those as well?
Yes, sir.
Are you in favor of the death penalty in every case where a murder's been committed? Okay. Is there anything about your views on the death penalty that would prevent or substantially impair you from serving as a juror in this case and following any instructions the court would give?
Yes.
All right, thank you. That will conclude the court's voir dire. Does the state have any voir dire questions?
We do not, Your Honor.
No questions, Judge.
All right, thank you, Juror 1382. That will conclude our questioning of you in individual voir dire. I'll have you return with the bailiff to the jury room and we'll give you some more instructions once we talk to the other jurors. Let's next talk to Juror 1436. Okay. All right, Juror 1436. All right, juror number 1436 is returned for individual Vore Dyer. We're going to talk to you about the knowledge you have about this case. You do have some. Please openly discuss any facts or details you're asked about. And why don't we start there with the state conducting Vore Dyer on potential bias.
Okay. Hi. So I have a few questions for you about media exposure. And there's no wrong answers. Obviously, you know, nobody's gonna hold anything against you that you saw in the media before you ever knew that you might be called as a juror on this case. So please just feel very comfortable answering these questions. You felt. So it looks from your questionnaire like you did get a decent amount of media exposure in this case. And you indicated that you felt that Mr. Daybell looks guilty according to the news reports.
Well, you know, I didn't see a ton of things and I can't even remember everything now because it was a while ago.
Sure.
But just the way the questionnaire was written, which I forget how it was exactly written, you know, saying, well, if you were to make a decision based on, you know, what you've seen in the reports and everything, then yeah.
Okay. So if you had to make a decision based on what you've seen on the reports, you would feel that he was guilty. Is that what you're saying?
Well, in the questionnaire, the way it asks,
okay.
Just kind of was like, you know, okay, so you were exposed to some media, so I did see some things on the news back then. It wasn't something I followed or anything, but you know, you see it, it comes on the local news or whatever. So it was like, oh, your perception, you know, they're implying something happened, he's in trouble, you know?
Sure.
So.
Do you mind kind of telling us what you do know about the case from what you saw in the news reports?
Let me think. Just that there was 2 people killed. I didn't know if there were 3, but there were two people killed, that were children. And that, you know, it involved the husband and wife, and that they ran off to Hawaii together. So that was pretty much, and that the bodies were found on one of the properties.
Okay. Did you watch any court proceedings?
No.
Okay.
Didn't watch anything like that.
And it looks like there was a comment in here that you wrote, he may be mentally ill. Do you want to kind of talk about that a little bit?
Well, I forget what the question was.
It was, have you formed any personal opinions whatsoever based on information from any source of Chad Daybell's guilt or innocence?
Yeah, my thought was kind of like if he or she had done something like this, that person would have had to have some problems that would cause them to do.
I
was trying to answer him honest.
Of course, no, that's great.
So it seems like a blanket statement, but that was the only way I thought I really could answer it on paper like that is, you know, I guess if somebody did something like this, something wasn't right.
Of course, no, and it's great that you answered those questions,
Okay.
honestly. That's exactly why we're all here, and we are all very, very appreciative of your willingness to be so open with us. And just so you know, it's very common for us to ask people who've had media exposure these very specific questions. Did you watch any documentaries about this case?
Oh, no.
Did you go looking for it on TikTok or anything like that? In the questionnaire, you did indicate that you had formed some opinions on Mr. Daybell's guilt based on the media reports, but you indicated that you'd be able to put those opinions out of your put out of your mind, which you had heard in the media. Is that still?
Yeah, the way I took kind of the questions being asked, like, okay, you saw so much, this is what you saw. What would your conclusion be from that? So that's kind of what I was answering when it came to actually being in a court and making that decision, those things would be put to the side.
Okay,
Miss Beatty here too, you are going pretty quick, and with this particular juror, I know it's been a real long day for our reporters, so if we can make sure there's no talking at the same time as well.
thank you, Your Honor.
Thank you.
I'm sorry, not a court reporter. So you're going to be instructed during this trial that Mr. Daybell is entitled to a presumption of innocence. That means that as he sits here right now, and up until the state is finished with its case, he's presumed innocent until we meet our burden of proof.
Right.
Is that something that you'd be comfortable with?
Yes.
And you understand that nothing that you see in the news or on TV is evidence?
Yes, I understand. Yes.
And the evidence is what comes out in court, testimony, any exhibits, anything like that?
Yes.
Okay. I have no additional questions, Your Honor. Thank you.
All right, thank you, Ms. Beatty. Mr. Pryor.
Good afternoon.
No.
We spoke earlier, but you have your questionnaire with you?
I do.
Okay, let's turn to page 14. Number 2 at the very bottom. Question is, what have you heard or what do you know about defendant Chad Guy Daybell? Do you see that? You wrote in there on trial for murder of several people. He may have mental issues. And I just want you to clarify, you said that's what you heard and that's what you know. So at the time of this writing, what you know is that he has mental issues?
No, I was just going on based on the news report and things that I heard about him. Because I mean, obviously, he wasn't on trial. So when I said that, I'm assuming that this person is on trial because of it, and I wasn't following it. So, but I was saying, just like I was telling her earlier, that first, if somebody did commit a crime like this, my initial thought would maybe there were some mental problems.
Okay. And is that still your opinion now?
What?
That Mr. Daybell has mental issues?
No, I was just going by the reports what I had read from the news media, and you were asking me if I could form an opinion from that, that would be the opinion I would form. I don't know if that makes sense.
Then we can go to page 19. Under item number 10G.
Yeah.
10D. And under 10D, talks about the media exposure, and again, lists here on the case, whether you formed an opinion of guilt or innocence. And you said yes.
Yeah, I kind of took the question as being, what opinion would you form based on what you've heard about?
And that's fair.
Yeah, so I was gonna give an answer to, well, this is, oh, sorry.
And when you wrote this at the time, which was, well, several days ago, I guess, right? You said, looks guilty. And you were basing that's your opinion at the time you wrote this, after looking at all of the media and everything that you've been presented, he looks guilty.
Yeah, if you go by what the information I received in the media,
right?
My initial thought is, yeah, that's probably guilty.
And that's fair, if that's what you believe. You also believe that at the time that you have to make your judgment, that you have to block out your personal opinion and look at regardless of whether you think he's guilty today or not, right?
Right.
You have to push that off to the side, correct?
Right.
And by pushing that off to the side, you then have to look at this thing and say, I have to be neutral despite the fact that I feel like he's guilty. Are you able to do that?
Yes.
But if we go back, your impression now, and I don't want to put words in your mouth, but the impression now is that, Mr. Daybell looks guilty and I think he's guilty. But if I get chosen for the jury, I will block that opinion of mine that I've already made and I will judge him fairly. Is that where you stand on this?
I don't know that I believe he's guilty.
Okay.
I just, I kind of took the questionnaire as it's saying, you got this information, what opinion would you form from this information? So that was the opinion form. I don't necessarily believe that he's guilty or not guilty at this point.
Okay. And that's,
But I know I could put that aside.
and surprisingly, that's exactly what I wanted to hear.
Oh.
And you gave me exactly what I wanted to hear. Judge, I have nothing further. Thank you. I appreciate it.
All right, thank you. So juror 1436, then just.
Your Honor, I'm going to move to excuse this juror. I'm going to sort of leave it to the court. I understand that she's saying she could put this aside, but given the depth of media exposure, we do have some residual concerns, Your Honor. So I just wanted to put that in front of the court.
Response from the defense.
I appreciate everything you've done. I don't know, but even the media judge, I think I would concur.
All right, there are some comments in there. There is previous exposure. This is a long trial, a complicated case, and as we've seen with many other people, we do have some concern that maybe thoughts and knowledge about where you already are might creep into where we're going in this case. And so you've been very candid with us. We appreciate that. I'm going to sustain the strike made by the state and with no objection from the defense. Juror 1436 is excused based on potential bias, and for that reason, we'll let you go. Thank you for taking all your time to fill out the questionnaire and returning today. I'll have you return your questionnaire to the bailiff, and your jury service is concluded.
Thank you very much.
You're welcome. So next talk to juror number 1503. All right, thank you for returning, juror 1503. We've got some additional follow-up questioning for you based on responses in your questionnaire, as well as indicating today in report diary that you have some knowledge about the case. Let's go ahead and allow the state to. There was also some talk of hardship, but let's start off with this knowledge of the case on board diary. If the state would like to start its board diary on that issue, you can do that.
Sure. Juror 1503, thanks for being here. And again, you've already heard this. There's no right or wrong answers. We just want you to tell us how you see things and think about things. And it looks like from your questionnaire, you have seen some media on this case, both from local, national news and internet. What have you seen on this case?
Yeah, basically just, like I said, a lot of print news, national as well as local. Some of the outcomes of some of the other connected parties, I guess, if you want to say it that way. Yeah, and like I said, just like a lot of news coverage, things that happen in Idaho, you know, whether it's Aryan Nations coverage or other type of activities that are high profile stuff, you know, you would read up about those kind of things. So just local interest kind of stuff. So.
Sure. And yeah, no one can hold it against you for wanting to read the news and being informed. You did mention just now, I don't know that it was in your questionnaire, but that you were aware of outcomes in a companion case, and I don't want to put words in your mouth.
Yeah, well, yeah. So in terms of the other people that were involved, like I said, I don't know how.
Well,
I don't know how I just
tell. Oh, sorry about that.
So yeah, I didn't know what was allowed, you know, in terms of details, in terms of that kind of stuff. Going into any more other than, like I said, you know, other people that I guess have gone to court.
Right.
Yeah, just what the outcomes of some of those things are.
And so we're in here just with you individually right now, so that you can be completely candid without worrying about anybody else hearing it. So it sounds like, did you follow the trial of Lori Vallow?
A little bit, but like I said, most of it was the outcome and what was finally handed down, I guess.
And so you know what happened in that case. I want to talk to you about a couple of your answers in the questionnaire. Starting with on page 15, at the very bottom, it says, if you did follow these cases, has that caused you to already form an opinion regarding the guilt or innocence of the defendant in this case? And you said subconscious opinions may have formed. Tell us what you mean by that.
So again, you know, I understand, you know, the presumption of innocence for any defendant. But again, it's hard for you to unknow things, right? And like I said, I can go in with the best intentions and saying, you know, I'm going to go and try to be impartial and do all those kinds of things. But subconsciously, there could be some influence from things that you've known or seen, or kind of things that subconsciously, and that's why I use that word, creep into your judgment or some of your decision-making process at that time. So, like I said, I think that was, I just try to use that phrasing to be as clear as I could.
Yeah.
For that. So.
Being honest about how you feel.
Yeah.
Is it fair to say that you, while you would do everything you can to set aside what you've heard based on your responses in your questionnaire, you do have some concern that what you have heard could affect your judgment in this case?
Yes, like I said, I brought that out to be as transparent as I can, and saying that again, it's hard to say, hey, I'm going to shut out all the things, because you know some of the things have been going on for years, and that things that we seen things or heard things over the course of years, and you can't just turn them off or just shut that out. You know, it's kind of almost like a known type of thing in your thought process, I guess. So again, like I said, you know, I would obviously try to do my best in terms of that stuff, but again, that's why I brought up that point to say subconsciously, you know, to try to be as above board as I could in terms of that thought process.
No. Very much appreciate your candor. And it just really quick, it does look like you watched local media, you said CNN, Associated Press, and Reuters on this. Your Honor, we very much appreciate Juror 1503's candor. Based on his answers, both in the questionnaire and here, we would move to excuse Juror 1503 for cause.
All right, response from the defense?
Judge, I think I have to.
Very well. Juror 1503, this is the process we're going through to try to get the most impartial jury we can, based on knowledge and information you have from a case that would likely affect your views in this case, or at least have the appearance they could. we're concerned. I support the strike and will sustain it. And so thank you very much for taking your time and energy to fill out our questionnaire and return when you were supposed to. Your service as a juror in this case is concluded.
Thank you, Your Honor.
Thank you. Uh, 1537 will be up next. Okay, our next juror we're going to talk to is 1537. Thank you for returning for individual Vordire. I know it's been a long day and afternoon for you. I'll just allow the state if they have any questions on either bias or hardship for this juror.
Now, Your Honor.
You may.
No, who's that?
No, I just confirming he's,
Oh.
the court was allowing me to go forward.
Yeah, Mr. Whitson, please inquire.
Thank you, Judge. Hello, sir. Again, I just have a few questions about questionnaire. There's no right or wrong answers. You're just trying to understand your perspective. I do, you have your questionnaire in front of you, sir?
Yeah.
Okay.
Yeah.
May I call your attention to page 8? I'm looking at page 8, paragraph 3, and you were asked a question. Do you feel that the jury should be free to disregard the law given in the jury instructions if they disagree with that law? And then you appear to have checked yes. You did make some side notes, some references to Nazis and remember who else. And I can't remember who else you may have mentioned in there. Could you please just explain the comment?
I think I was referring to also the Fugitive Slave Act back in the day, where if you didn't help someone return to slavery, you could be arrested for it. And I think that would be wrong to do. So I think the jury in that case, and if they were in Nazi Germany, some evil law like that, that should be allowed to disregard.
Okay. So do we take that then, if there's something about the legal instructions that this court gives, if you sit as a juror, hear all the evidence, and then feel like you're put in a place where you feel like it's an unfair law, are you indicating that under your conscience, you wouldn't necessarily follow the instruction or follow the law?
Well, this law that supposedly was broken or accused of breaking isn't an unfair law. And I think it was just referring to it in general. That's how I read that question. So, okay, I think there was certain scenarios where it's okay.
Okay, so you don't anticipate having a problem generally following this court's instructions?
No.
Thank you. And I'm just going down to a quick reference on page 15. You had noted that you were not really familiar with this case and haven't really followed media, but you did know I heard of Lori Bell from the news. Can you just let us know what is it that you remember about Lori Bell?
I think what I really remember was when everything was going down, my coworkers back in the day, like maybe 3 years ago, were just saying, whoa, this is a crazy story. And I remember that name. And I think recently she was
convicted possibly.
Do you happen to remember any of the other names that have come up in the case, like the alleged victims' names?
No.
Do you remember where the alleged crimes had occurred, anything like that?
Like Idaho.
Is there anything then about what you have learned from the news that would make you think that you wouldn't still be able to serve Daybell a presumption of innocence, listen to the evidence, and remember an impartial verdict?
Can you say that again?
Is there any reason to think that you won't let him have the presumption of innocence?
No.
Okay, just a last question, and really, if maybe I'm thick, I just want to make sure that I do understand you clearly. If in this case, you are a juror, and the judge gives you a set of what will likely be a large number of different instructions to follow, and that will be what will be the law in this case for the jury to apply. If in any event that any given instruction that you see does not feel fair or right or moral to you, will you still be able to apply that instruction as the judge has given it to you, even if you feel it to be immoral or wrong?
I think I would be able to follow the instructions in this case, yeah.
Thank you. Your Honor, I don't believe I have any more questions.
All right. Okay, no further questions for this juror on those issues then. So juror 1537, there's one other topic I want to go through with you, and that's on the part of your questionnaire called attitudes regarding the death penalty. That's on page 12. Do you remember going through those questions last week and answering them in your questionnaire?
Yeah, yes.
And are your responses there still the same as the way you feel today?
Yeah, it seems like my answers were basically just kind of, I waffle a lot, so that's accurate.
And that is fine. Part of the way that the questions are designed is to get people to think about it and be accurate in how they feel. So in filling those out, maybe that's more of a thinking about things hypothetically, but here in this case, it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty. So when you're thinking about these answers, please consider that it should be done as if it would be absolute and carried out in the case. So you had an answer on, do you oppose or support or oppose the death penalty? You said support, and you said very slight lean, I think. Is that what you were saying?
Yeah.
Okay. You also had a group of 7 choices about what most accurately represents the way you feel about it. You circle part C, which says you generally favor the death penalty. I'm sorry, I'm going to read that. I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that the way you still feel about the death penalty now?
Yeah, yes, sir.
All right. Are you in favor of the death penalty in every case where a murder has been committed?
No.
All right. Finally, is there anything about your views on the death penalty that would prevent or substantially impair your ability to serve as a juror or perform your duty in this case?
I don't believe so, no.
All right. So you would follow court's instructions regardless of whether that was to consider or not consider the death penalty?
Correct.
Very well. Thank you for your answers. Does the state have any additional board doc?
We do not, Your Honor.
Nothing further, Judge.
All right, without further voir dire, then juror 1537, we have one other juror to talk to, and then we'll have you return to the courtroom for more instruction. That will be juror 1577 next. All right, thank you for returning juror number 1577. We've got some additional questions for you outside the presence of the other jurors. State have any board dire as it relates to any potential bias in this case?
Just briefly, Your Honor.
Go ahead, Ms. Beatty.
Good afternoon, ma'am. Hi. So you had some media exposure in this case, is that correct?
If I did, it was passively. I don't watch the news, so if it was on TV at a restaurant, it was there, but I don't participate in watching the news.
And in your questionnaire, you indicated that you haven't formed any opinion about
No.
Mr. Daybell.
No.
Is that still true?
It is.
Okay. I have no additional questions for
No
this judge.
questions.
All right. All right, there were no further concerns on hardship either, so the court will next address this part of your questionnaire dealing with the death penalty and your attitudes regarding the death penalty. Do you remember going through those questions and answering them in the questionnaire last week?
I do.
Okay, I'm gonna advise you that it may be necessary for you in this case to make a determination in regard to the imposition of the death penalty or some other penalty. Remember that any penalty you consider should be done as if it is absolute and will be carried out in this case. Do you understand that?
I do.
All right. In your questionnaire, when you were asked if you support or oppose the death penalty, you said you support it. Is that still the way you feel today?
Yes.
In addition, when given a range of choices about what most accurately represents the way you feel, you selected an option that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty as well?
Yes.
All right, so to be clear, that part that says you would follow instructions in the case, you would be willing to do that?
Yes.
Do you favor the death penalty in every case where a murder has been committed?
No.
Okay, is there anything about your views on the death penalty you haven't mentioned that you think would substantially impair or prevent you from serving as a juror in this case and following instructions relating to the death penalty?
No.
All right, that concludes the court's voir dire for this juror. Does the state have any voir dire?
No, thank you, Your Honor.
That's okay. All right, thank you, counsel. Juror number 1577, if you'll return to the jury room with the bailiff, we'll have you back here shortly. Counsel, could I have a quick sidebar with you before we bring the jurors back in and adjourn for the day? Thank you. Please be seated. We're going to have this jury panel then brought in for passing for cause. If you could instruct the marshals, please have the ready name jurors brought in.
Judge?
Yes.
Council approach briefly.
Yes. Thank you. Please be seated. All right, we're going to take a final inventory of the remaining jurors here to match against our seating charts. If you wouldn't mind, please hold up your red cards and we'll take our notes. Okay, thank you. I'll inquire of the state now, and we are back on the record in the case here. Does the state pass this remaining small group for cause?
Yes, Your Honor, thank you.
Does the defense pass this small group for cause?
Yes, Your Honor.
All right, thank you, counsel. Ladies and gentlemen of the jury, you've now been passed for cause. We're going to continue on with our proceedings and have you contact our jury commissioner, Randy Rutland, on your way out, who will give you further instructions regarding when you will return. While you're waiting, please don't do anything to investigate the case, look up the case. If you see the case passively in media, please try to avoid any exposure to that so you can remain impartial in the case. And don't discuss the case amongst yourselves or with anyone else. However, you are permitted to discuss the fact that you may be serving as jurors with family, friends, employers, etc., to make arrangements, but don't engage in any discussion about the case or the facts. We will be asking you to sign an affirmation coming back that you have followed that instruction. So with that, that will conclude our juror selection for today. Does the state have anything further before we adjourn?
No, Your Honor, thank you.
Anything further from the defense?
No, Your Honor.
All right, thank you. Counsel will adjourn until tomorrow. All right. Thank you.
Thanks for watching with me. Thanks for watching with me, everyone. I will see you. Hope you have a fantastic rest of your day. Please don't forget to hit the thumbs up, like, and subscribe. Thank you.